open us with our public disclaimer, please.
Okay. Notice of the November 9th meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 19th, 2021. Additionally, this month's agenda has been posted on the website since Friday, November 4th, 2022. Now for the roll call. Commissioner Joe Begley. Here. Commissioner Jeff Diaz.
Here.
Commissioner DJ Ferris.
Here.
Commissioner Steve Gwynn.
Here.
Commissioner John Moffitt. Here. Commissioner Joan Smith. Here. Commissioner Stacy Torbett. Here. Commissioner Kathy Tucker.
Here.
Chair Marcia Franks.
Here.
You have a quorum.
Thank you. All right, I'd like to ask Ms. Torbett if she would at this time lead us in a prayer and pledge to our flag, please.
Bow your heads, please. Dear Heavenly Father, thank you so much for the opportunity to be here. Thank you for everyone's safe travels and everyone's health today. Protect us all as we travel back home later this afternoon. Bless our efforts and help us to honor you with our words and actions. Give us wisdom and discernment in the decisions that we make today. In Jesus' name, amen.
Allegiance, flag, United States, Republic, God, indivisible, with liberty and justice for all.
And I'd like to begin the meeting by saying happy birthday to Ms. Torbett, that she's spending her birthday with the Real Estate Commission today. All right, next we're going to look at the approval of the agenda. No.
Move to approve.
Wait a minute. We do have a 12 p.m. formal hearing on the agenda.
Yes, that should change to a settlement offer.
Okay, so we're taking that off.
We're taking it off and changing it to something else.
There'll be a discussion about it then?
It's provided for you in the addendum to the consent agenda, so it can be removed from the agenda.
Okay, we'll take that off. Any other corrections or edits? Do I hear a motion?
Yes.
I'll move to approve with the removal of the formal hearing.
Okay, we have a motion by Commissioner Ferris and a second by Mr. Moffitt. All those in favor?
Aye.
All those opposed? Motion carries unanimously. Next, we have the approval of the October 13th, 2022 minutes. Any edits or changes to that?
Marcia, I'll abstain since I was not present.
We have a proper motion by Mr. Diaz and a second by Commissioner Smith with one abstention of Joe Begley. All those in favor of approval of the minutes, say aye.
Aye.
Any opposed? That motion passes unanimously, except for one abstention by Mr. Begley. Okay. Next, we're going to our informal appearances. Are candidate A and candidate B both here?
Candidate A is Kelly Turner. Are you on the line?
And is this the same one that last
Yes,
month didn't
yeah.
appear?
Yeah. I think we can make sure the others are here. Is Countess Brown here? Mario Gomez?
Yep, I'm here. Yes.
Okay,
yes,
thank you.
Okay, so we didn't have Mario Gomez in our packet. Is that some new information?
He was emailed yesterday, and he is on your iPads.
Okay, so if the commissioners would take a look at that first. Commissioners, are we ready to move forward? Good morning, is it Mr. Gomez?
Yes.
Okay, and is your principal broker with you?
Yep. Kurt is right here with me. And
Who is your principal broker?
Kurt Stefo.
Okay. Kurt
Chair, I can read a summary.
Eckel. Okay.
Yes. Before you have applicant Mario Gomez and his principal broker, Kurt Steckel. As of the time of this writing, Mr. Gomez had not taken the exam yet. The firm is Dream Team Franklin, LLC, doing business as Keller Williams. A summary of the criminal disciplinary sanction is felony assault. Mr. Gomez's statement and letter recommendation can be found in your packet.
Okay, thank you, Ms. Maxwell. Now, Mr. Gomez, what we're going to do is we would like for you to tell us whatever it is that you would like for us to know about what happened, why you're before the Real Estate Commission, maybe what you've done since this occurred, and if you'll just explain exactly what it was that occurred, and then after you finish that, then the commissioners will be able to ask you some questions. Then we'll move to your principal broker, who can say what he needs to say, and then we'll be able to ask him some questions. Did you have a question, Mr. Mobbitt?
Yeah. Can we see him? We can't see him.
If you guys could turn the camera slightly, or if maybe Mr. Gomez could we can see Mr. Yes, there you go. There you go.
Okay.
Thank you.
That'll work a little better?
Much better, thank you.
Fantastic.
Okay, Mr. Gomez, we're ready for you.
Perfect. My name is Mario Gomez. I'm originally from Denver, Colorado. Back in 2012, I got in a confrontation and was convicted of felony assault in 2014. I went to the University of Colorado at Boulder, where I met a young woman, and we became really close friends within that the next year. I found out that she didn't attend school the last year. She said for medical reasons, and like I said, we became close friends. I rushed for a fraternity that year when I transferred over there and made many friends. During that time, I made friends with other fraternity members from other clubs, and I was invited to a party. I brought her, since she was one of my close friends at that time, to that party. And during that session, I introduced her to one of my other friends that was over there, and she completely shut down when she saw him. She completely shut down when she saw him and started frantically crying and panicking. And then suddenly he started getting really aggressive with her. And then when I confronted him, many words were spoken. And I asked, when I went over to her, I asked her what happened, and she said that she was raped in the previous school year, and that's why she was medically off leave. And when I talked to him and confronted him about it, like I said, he said many things that were affronting, and me and him ended up getting in a scuffle, getting in a fight where he was injured in the accident. I was about 22 when this happened, and now I'm about 32.
So, what have you been doing? What exactly happened? What were you sentenced to?
I was sentenced to 160 hours of work crew, which I would work do community service, and then I was sentenced with 3 years probation. 2 years probation with that, and I successfully completed that in 2016. Should show that on the papers, and since then I've been a participating member of society. I've worked in many numerous jobs, and I currently have a passion for real estate. Since that girl that was affronted, we ended up marrying each other. We have 3 kids. I have 3 sons, And currently, right now, we are running a couple of rental properties, and our goal is to get into real estate so we can continue that process, if that makes sense.
Some of the commissioners are having a hard time hearing you, so if you would speak a little bit louder. So he was saying that that he ended up marrying that girl, and they have 3 sons. I think he said.
Yeah, we ended up going later. We ended up marrying each other later on. We have a stable relationship. We have 3 sons, and we currently live in East Nashville. But yes, I was young when that occurred. And I'm hoping that the things that happened in my past, in my early 20s, don't affect me in my 30s, since it's almost 10 years. I'll be
Okay, and what were you charged with?
I was charged with felony assault.
And you were given 2 years probation, a fine, and public service. Have you completed all of that, including your probation?
Oh yeah, I completed that back in 2016.
Okay.
I was successfully completed in 2016. So.
Would any of the commissioners like to ask Mr. Gomez any questions? If not, then we'll move on to Mr. Steckel, and he can tell us what he knows about you and what his plans are for training you and how he knows you.
Good morning. I chatted with Mario on a conversation based on what happened 8 years ago. I feel comfortable with what happened at college time compared to where it is today at 32 years of age, married, the girl from college, has 3 boys, and he looks from having full-time jobs he's already had. He's in a position now to go full-time into real estate based on what he's done in the past, the money saved up, and moving forward. So I'm very comfortable with him going into it full-time. The training we have here at Keller Williams is top-notch. We're ready to start as soon as he's approved. He's always signed up for that. And I'm ready to train him. I have classes myself. I teach 3 times a month that Mario will be attending, plus the other classes we have over the next 7 weeks that he'll be attending too. So I'm very comfortable with Mario coming on board with us for the work.
Okay. Do any of the commissioners have questions of Mr. Steckel? Okay. Mr. Diaz?
Mr. Steckel, just how many agents do you have under your supervision at present?
We have 413 out of a staff of 11 of us.
Mm-hmm. And do you have different brokers that handle those?
Yes, I have an additional broker with us. Linda Pennington has been with us. She's been having the business 16 years and been a principal in a couple of other companies for about 14 years of that. So she also helps me with that, yes.
Any other questions?
Make a motion to approve this candidate.
Second.
All right, we have a motion to approve this candidate by Ms. Torbett and a second by Mr. Moffitt. Any other discussion? All those in favor, say aye.
Aye.
Any opposed? Congratulations, that motion carries unanimously. Good luck to you, Mr. Gomez. I know you have a good broker there, and just make him proud. Thank you for being here.
Yes, ma'am. Thank you very much. Thank you, guys. Good.
Okay, so Ms. Turner, or is it Ms. Brown? They?
I believe so. I don't know that either of them. Is Kelly Turner or Steve Black on the line? Countess Brown or Robert Matt Lang?
Showing that Countess is waiting in the lobby.
Okay, I'm going for it.
Hi, Countess Brown. Can you hear us? Miss Brown, are you able to hear us?
I am. I'm sorry. I couldn't hear you at first.
Okay, thank you. Is your principal broker on the line as well?
No. Matt, are you on here? No. I went to the office this morning and he wasn't there. So.
Okay. If you don't mind, if you don't mind muting, and if you could contact him, we'll need him on the line as well, in order to proceed with your appearance. And so once he gets on the line, we can present you, but we can't until you and your principal broker are both here.
Okay. I will give him a call now.
Okay. Thank you.
You're welcome.
So, Ms. Maxwell, it's hard for me to see the boards. When people come on, if Ms. Turner or Ms. Brown's principal broker, will you?
Yes, I'll alert you.
Alert me. Okay. All right.
What happens if people just continue to not?
I mean,
you've never had that happen.
We have not had that happen. It seems odd. I've seen the same Kelly on both times, but we called for this first informal appearance multiple times at the last meeting and never had anybody speak up. During the break, I can talk to Aaron and we can try to reach out again and just see what the deal is and reach out to them today.
Yeah, so I don't think we need to continue keeping her on our agenda unless she contacts us.
Yeah, I mean, have you
No,
spoken to her?
I think she reached out. He's on the phone with somebody, so it could be them.
Okay.
Unfortunately, we tried to use another computer today, and Aaron does not have his computer. That's his computer that we're having to use.
Okay. So we'll just move on, and you just alert me if.
Yes, and I feel pretty confident that Aaron would have just carried them over from the agenda.
Yeah.
Yes.
Okay. All right. So next is Mr. Anthony Willoughby. He's not scheduled to 9:15. So.
Yes, and he did reach out and say he's on his way, but he was stuck in traffic. So.
Welcome to Nashville. Mm-hmm. Okay, so if it's okay with everybody, we'll move on to the next thing, the legal rulemaking hearing. And I think that's what a lot of people are here for. So is that okay, Ms. Maxwell, Ms. Matlock?
If we want to you want to do the education report real quick and then you'll be ready. Would that be okay?
Okay, we'll do the education report then. Good morning, Mr. White. He's our Director of Education. How are you this morning? I'm great, thank you.
Ross, I think you might be on mute.
Yes.
There we go.
Thank you, Ms. Chairwoman and members of the commission. I'll present to you this morning the education agenda for November 9th. And I want to say I've reviewed all the providers, the courses, and the instructors for today's meeting. And I will present them for your approval this morning. That would encompass N1 through N33.
Does anyone have any questions about any of these courses? Okay. Make sure your mic is on, please.
So, like number tax laws and their impact on anyone owning or selling real estate. So I'm a little old school, and I always thought we just said we weren't accountants, weren't lawyers. So does that give agents, young agents, like if you're teaching them that, are you kind of pushing them like that they're going to discuss that stuff with clients, and is that where we want to go? I mean, does anybody else have that same feeling or not? No.
Yes, I agree. And I will say, though, that there have been some other courses that have been approved.
Yeah.
But, yeah, I mean, I'm always saying I'm not an attorney.
Right.
And can't give any kind of really legal or financial advice. But
how deep they go and how much.
Commissioner, this of course, the commission has approved this course. This is the second time around for it, and essentially it'll be like a renewal of this course. They have many. Appalachian School of Real Estate. Mr. Walden has a good background now, but this is a generalized course. It's not specifics, so it does, I think, help to at least get those in the industry sort of ensconced into understanding about how real estate finance affect the taxes. But it's not a true legal course in the sense of having to be a lawyer. I look out for that when I review these things, and that's as it's coming to you again. That I think we may have discussed it last year, but that's the way it is on this one.
So there's enough content for 6 hours credit.
Yes.
If they're not going into detail, that makes me wonder, what are they doing for 6 hours then?
I'm just saying that, essentially it's not something like a law course. As a lawyer myself, I realize that, they're not using law books and they're not going to the detail of plaintiff, defendant, and so forth. However, it is what it is, and the commission has approved it before. But I'd present it for your approval this morning. I don't have any problem with it.
But Mr. White, I think you and I went back and forth on this the last time it was up for approval, because I had the same concerns as Commissioner Begley. So I think my concern was disclosure statements at the beginning, reminding agents you're not tax professionals. Your best advice to your client is to consult a professional.
Always. Yes.
So are those disclosures in that class still? Or?
Yes. In the beginning of the contents, that's something that they would have to say. They would have to explain that.
That was in his syllabus that he does that?
I can't say for sure that's in the syllabus, but I believe it is, and I believe it's having reviewed it before, having the discussion before, that it's not something of a nature that an attorney would definitely be required to teach it.
Is Mr. Walden an attorney?
I do not think so.
Okay. And when you have a reapproval, do you have to go and look through the syllabus and see if anything has been changed, or is it just a reapproval?
It's just pretty much a reapproval unless there's been a change in the course. They have it's on them to have to provide additional documents if they've changed the course in any way.
I think one thing that we could ask you as a group is to, when you have courses like this, if you can kind of, I don't want the word flag, that's too hard a word, but if you could notice as this class takes place, how many are in the class, that kind of thing. And, you might even reach out to Mr. Walden, just a quick email and saying that we were concerned that he did disclose it, if that was okay.
I'll do that.
Okay.
I will do that.
Anything else, guys?
Is there
1 second. Okay.
is there a way for us to be noticed and for us to see which ones are up for reapproval and which ones are new?
Well, this is sort of a commissioner. This one came to me. He had sent all his courses, 38 courses, and I've divided them up over 3 months. I've explained to him that actually he should have waited until this week. They're going to begin. Most providers are going to get their announcements, their renewal notices, but this provider sent everything in early to renew, and I told him, well, you can't do that. Now I can put it back on as a course, and because of the time that we're in right now, in November, it can be approved for the next 2 years as a renewal, because we're beginning now to get renewals in. So he agreed to that. He apologized, and that's kind of why we're here today with it.
So the renewal period starts January 1, not November?
Actually, the renewal period, I think by the statute, is at least it opens September 1. But because of the way our process goes, and we have to have the help of the IT section and so forth, and physical needs to understand what's going on, then it's come down to this time. And so I'm able to take the courses in here that are, if approved today, and then I would mark them for just as I would in a renewal. And I had that understanding with this gentleman.
Steve?
Yes, I think it's a good thing myself. Anytime you can educate an agent on the tax code, I don't think people are expecting agents to basically file their tax return or give them legal advice or tax advice, but an agent that is generally knowledgeable about the tax code is a good thing. And I think their customers, their clients, are expecting them to have some knowledge of what's going on. And as a citizen, I mean, people need to know what's going on the tax code, generally speaking. So I'm all for the course myself.
Anyone else on that one? Okay, I have a question on N15. This is a new school, All Pro Home Inspections, and a new instructor, Collins Horton. And on N15 is a course by a home inspection company on realtor safety. So I'm wondering, what credentials do they have to teach a realtor safety class, or do you think that's something that anyone could present?
Generally, Commissioner, I think they have the background necessary to teach this particular course, and there's a little bit of story on this one too. All Pro Home Inspections actually was an approved provider back several months ago, but they saw to it when they sent their application in this time, they sent it in as if they were a new provider, marked it as such, and so it got the system. Now we'll have to get IT to sort of blend the two, and so we'll have All Pro Home Inspections with just one provider number. But essentially, they are an approved provider. They are about home inspections, and so they have knowledge of how to deal with safety-related issues as it relates to inspecting a home. And so with that background, that's where this is coming from. It is a little bit more generic, I think, than having somebody teach them about, how to carry a weapon or, provide for that sort of training. But the background in this course, and we have other providers that teach a realty safety course. So it's not, and it is, unfortunately, the culture we live in. The more you know about that, it's important, and certainly as a professional, you need to be aware. And this course is sort of a situational awareness type course. And so, yes, I think as a home inspector, I think they have a lot of understanding that we would not generally. They are licensed and certified, and I believe by this department. So I feel confident that this course is based on good background, and so I offer it for approval.
So are home inspectors required continuing education after they're licensed?
I do not know, but I
Yes,
have to defer.
Yes.
They are.
They're required to obtain 32 hours of continuing education every 2 years.
And so some of that education could be in safety. That's where I was going with the question.
It's not specific how much what the
courses are.
Courses they are. I know their attorney.
Okay. Okay.
Motion to approve N1 through N33.
Okay, I have a motion by, let's see, where am I here? Mr. Diaz, and a second by Ms. Smith to approve the education report, all those items. Any other discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously. Thank you, Mr. White. And now on to the new educators.
Thank you, Madam Chairman. Moving forward, you have before you two new instructors for your review and approval this morning.
Anyone have any questions about these instructors?
Motion to approve.
Second.
All right, I have a motion to approve by Mr. Diaz and a second by Ms. Torbett. Any other discussion? All those in favor of that motion say aye.
Aye.
Any opposed say no. That motion carries unanimously. Thank you, Mr. White. Is there anything else that you needed to bring before the commission concerning education?
This morning, I believe that pretty well covers it. However, I did, as mentioned earlier, we do have renewal period going on, so I'm in the process of renewing a lot of courses and instructors. So that's sort of what's going on these days with the education department.
Great. We appreciate you.
Thank you, ma'am.
Thank you.
Thank you, Commissioner.
Okay. So are we ready to move on then to the legal rulemaking hearing? All right. And Ms. Matlock, are you the one that's going to present to us on that? Commissioners, you have the rule. You have 2 sheets about this.
Also, I think the document should be on your iPads as well. This rulemaking hearing is called to order. My name is Anna Matlock. I serve as an Associate General Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee Real Estate Commission. Would the agency representatives who are present introduce themselves for the record?
Caitlin Maxwell.
And if the commissioners will introduce themselves, beginning with
DJ Ferris.
Steve Quinn.
Joan Smith.
Portia Franks.
Jeff Diaz.
Stacy Torbett.
Joe Begley.
Today is Wednesday, November 9th, 2022. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1A of Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and also available by electronic means via Microsoft Teams, which can be located on the Commission's website, www.tn.gov/regbboards/trek/public/meeting-information.html. On this page, the link for access to this rulemaking hearing via Microsoft Teams can be found in the chart located in the middle of the web page in the second row with the date 11/9/2022 in the location column under the words Nashville, Tennessee, labeled Connect. The purpose of this rulemaking hearing is to solicit comments on rule amendments to rules and regulations of the Tennessee Real Estate Commission. The first set of rule amendments update the disclosure of rescission rights required for every contract for sale of a timeshare interval. The amendments clearly number the 3 methods of cancellation and include the added third method of notice, email. Lastly, the proposed rule amendments now require timeshare intervals to provide the disclosure of rescission rights exactly as written, which will create conspicuous attention, uniformity, and clarity to this language for all prospective consumer buyers. The second set of rule amendments update requirements and guidelines for distance education courses. The rule amendments includes specifying the regulations related to printed course materials or synchronous courses and general additional requirements for licensees to obtain credit for distance education courses. Additionally, guidelines for students, course providers, and course instructors are created for synchronous distance education courses. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet located to the right on the podium. Those members of the public wishing to speak and appearing via Microsoft Teams should place their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet and typed their name in the chat box, and those who have typed their name in chat box will be permitted to speak. Is there anyone else that desires to offer oral comments but who has not written their name in the sign-in sheet or typed their name on the chat box?
Is there anyone in the audience that is not signed to speak if you want to speak? Or anyone online?
Seeing that there are none, for those attending this hearing in person, I would call your attention to the table located directly to my right, this podium. On this podium, you'll find red line copies for the rule amendments addressed in today's rulemaking hearing. I have about 5 copies of each. For those attending on Microsoft Teams, you will find a link in the chat box to red line copies of the rule amendments for today's rulemaking hearing. The notice of rulemaking hearings included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on August 18th, 2022.
Matlock, do you have the list of those wishing to speak?
I do. I don't have a list. There's not a listing yet. Ms. Maxwell, what additional notice was given to the affected individuals or groups?
Notice was sent out via Get Notified, a service offered by the department, and it was also posted on the website.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit each comment if they become repetitive, so please limit your comments accordingly. So I will now summarize the substance of the proposed rules into the record. I will first begin with the rules for rescission rights. Rule 1260-06-04 is amended by deleting the text of the rule in its entirety and replacing the text by including subsection A, which states every public offering statement, and subsection B, every contract for the sale of timeshare interval immediately above the space reserved for the signature of the purchaser. And then paragraph 1 states, you may cancel a contract to the purchase a timeshare interval within 10 days from the date of signing the contract where you have made an on-site inspection of the timeshare project before signing the contract, and if you have not made such an inspection within 15 days from the date of signing the contract, you may elect to do so by, there are 3 different methods. The first is hand delivering notice of cancellation to the other party at an address within the designated period for voiding the contract, or mailing notice of cancellation by prepaid United States mail at an address postmarked any time within the designated period for voiding the contract to the other party or to the other party's agent for service of process, or 3, sending notice of cancellation via electronic mail at the address time-stamped with the designated period for voiding the contract to the other party. The second set of rules will amend the Chapter 1260-05 educational requirements. The first rule that is amended is Rule 1260-05-.11. The first change that will be amended is the title of the rule will change from correspondence courses to printed material. The definition for distance education has been removed from this chapter. You'll see a renumbering of printed material for the rule. Additionally, the information for computer-based/disk/online material has been removed from this section of the rule. Next is Rule 1260-05-.18 distance education. This is a new rule. The definition for distance education has been placed into this rule. Also, subsection B, 1B, defines the term asynchronous course, which means a course offered to students at no specific time, where the teacher and student are separated by both time and distance. Subsection C defines the term synchronous course, which means a course offered in real time, where the teacher and student are separated by distance. The second paragraph is titled certification, and it includes the requirement for distance education, for certification required for the courses for distance education must be by the Association of Real Estate Law Officials, Real Estate License Law Officials, ARELO, or another certifying body at the discretion of the Commission as to the technology support or to the support technology interactivity and course design. There is an exemption into this particular provision, as it does not apply to synchronous courses, but does apply to asynchronous courses. Subsection 3 outlines the synchronous course guidelines. 3A provides the requirements prior to the scheduled course dates, which includes what the instructors must provide to the students, including course date, start time, and the course link to the Commission's Director of Education. What instructors are responsible for ensuring that students comply with all course guidelines and requirements set by the Commission. 3B provides what students and instructor course requirements. 3C outlines the requirements prior to course start time. 3D requirements during the course outlined for students, such as students must be visible on camera at all times, cameras must remain stable, and other provisions. 3E provides the course conclusion requirements. 3F states that the Commission may add, amend, or delete any of the above-mentioned guidelines by means of reasonable written notice to the course provider and instructor. Paragraph 4 states that the Commission will review the certified courses on a case-by-case basis to determine the curriculum will meet the education requirements. 5 states that courses over 8 hours must require a final examination. 6 states the approval of distance education or correspondence courses will be withdrawn should certification be discontinued for any reason. And 7 states any distance or correspondence courses of the Principles of Real Estate course required by applicants of an affiliate broker course as listed by TCA 6213.303 must include at least 1 student interaction with the commission approved instructor for every 5 hours of credit. Ms. Maxwell, were any written comments received by the Commission Office for rule amendments to Tennessee Comp R and Regs 1260-06-04, disclosure of rescission rights?
No.
And Ms. Maxwell, were any written comments received by the Commission Office for rule amendments to 10 Comp R and Regs 1260-05-0.11 correspondence courses and new rule 10 Comp R and Regs 1260-05-0.18 distance education?
One set of comments was shared with me by the legal division.
Yes. I will now read comments that I have received via email prior to this hearing. To date, I have received one comment from Mr. Bill Weisnett, the co-founder and owner of Tennessee Real Estate Educational Systems, Inc. Mr. Weisnett has provided a substantial amount of commentary related to the rules. The comment to the rules are provided for you on your iPads. We will go through each comment and its response, and the commission will then be permitted to provide comment. So once you find the comments on your iPads, let me know, and we'll begin.
Has everyone found that place on your iPads? Mr. Quinn, you have them.
Tennessee Real Estate Educational Systems, Inc., Trees, Inc., comments regarding the Tennessee Real Estate Commission rulemaking hearing November 9th, 2022. I'm Bill Weisnett, co-founder and owner of Tennessee Real Estate Educational Systems, Inc., or better known for the past 47 years as Trees, Inc. I want to thank the Commission for the opportunity to present these comments concerning the proposed changes to Rule 1260-05-0.18 distance education. I regret that I'm unable to be physically present at this hearing, but I ask the Commission consider the following comments based on our experience since 2020 of conducting synchronous pre-license course for new affiliates in office and brokerage managed courses via Zoom video conferencing platform. 1. 1260-05-0.183 Synchronous Course Guidelines A. Requirements prior to scheduled course date, paragraph 1. This proposed paragraph requires a school to provide the course date, start time, and the course link to the Commission's Director of Education no later than 5 days prior to the scheduled course date. Since schools teaching Commission-approved classroom courses do not submit course dates and start times to the Commission, and if a synchronous course is taught by the same syllabus as the classroom course, it is suggested that this paragraph not apply. Also, since all synchronous courses are recorded, if there is a question of compliance, the Director of Education can easily view the recorded course by contacting the school for a link to the recorded course in question.
So we can discuss that one.
Yes.
Okay. Anyone have any thoughts on those comments? Mr. Diaz.
So my recollection, the language for this paragraph was included because we wanted the education director to survey a course while it was in progress. Is that correct?
I think some of this was carryover from the guidelines that were in place during the pandemic when the executive order was in place and we were allowing this. But I do think it was originally included to allow the education director to randomly attend a course if he wanted to just sit in, potentially audit the courses.
That's correct.
Right. So not something that would be logistically possible for a classroom course to just show up and
Yes. No. Yes.
having the link 5 days prior would give him a chance to consider which courses he wanted to peek into and take a look and see if they're complying.
Right.
So I think this gentleman has an objection to that, that he doesn't want to give the 5 days notice to the education director. Is that correct?
Correct. And one thing I guess we should probably talk through is if there's a requirement for them to record the course. There is, or yeah. Okay. So I think it seems like what he's asking is that instead of doing it on the front end, only doing it on the back end when necessary.
Mr. White, do you have any
Madam
thoughts on that?
Chairwoman, members of the commission, as education director, I'm not as concerned about the, I guess, the 5 days or some time limit. Rather, I am more positive and concerned about having a link to that course so that I can join in or so that I can look into it. But the 5 days is not something. As long as I have and let me back up. What they're doing now is Trees would send me a request to have a course in December the 13th or whatever, at a certain location with a certain instructor, with a certain proctor, and the course is about with the course number. So I have all that information, and they include a link. As long as I have that, then I wouldn't need. I don't think the 5 days is an issue.
But don't you think you need that? To me, it's. My husband has this saying: "It's easier to get forgiven than it is to get permission." So I'm wondering, isn't that something that you would need in advance? I just hate that if something happened during the course that wasn't appropriate, that.
Yeah, I think the issue is, excuse me, Ms. Matlock. I think the issue that we're wrestling with is, at what point do we find out that they're not complying?
Right.
You know, if they've done a number of courses online already, and then we get a complaint that they're out of compliance. Well, you know, some number of students have already gone downrange without the course complying with the requirements. So that's, I think, the purpose of getting the link on the front end so we can catch that before it becomes a larger problem.
And it's only a matter of emailing you that, you know, these are the dates and times. Yeah. I don't see why. I don't think it puts any undue burden on the instructors.
And you say Trees is already doing this with you? They're already sending you this stuff?
You know, all providers that are offering the courses, they do at least send me a courtesy request to have it at a certain date and time, send the link, so I have that information. But that's crucial to me. The 5 days, it could be, 2 days, but I think this provider's hanging up on the language that's already there. So I'm not sure, and deferring to council, if that 5 days is already there, I wouldn't want to change it. I think we'd leave as is.
And is that 5 days in statute or rule?
These are rules. So.
Okay. So, any comments from the commission?
I'll look at this, Ross. Is this not a notice provision, essentially? Meaning, it's a 5-day requirement to provide the date, time, and link. I don't understand what the problem is with that. Why does?
Frankly, Commissioner, I don't either, and I just see it as I do need that information, but I'm not hanging my hat on the 5 days. It could be 4 days, but I need it. I need it prior to, so that I can have the time to plan and be there if I need
schedule
to.
It.
Right. But his complaint is 5 days. He's not saying, let's go 4. Right. He's saying, let's go 0, right?
Yeah. which
Okay.
I would oppose as far as
Right.
that goes.
Any other questions?
Two, 1260-05-.18, 3, synchronous course guidelines. A, requirements prior to scheduled course date, paragraph 2. This paragraph concern proctors. It is suggested clearly to state in this paragraph that an instructor can be a proctor.
Mr. Diaz?
So I think I've heard from at least the education director in MAR that the issue with the instructors also being a proctor is that they can't teach a class and monitor that everybody is paying attention online. And I think that was the hardship for the instructors. So I tend to agree with that. They're instructing, they can't dance from the center of the room to their computer screen and monitor everybody. So that's the reason why we wrote the rule in such a way that instructors would not also be proctors, so that there would be a separate individual who could focus only on the people that are participating online to make sure they are complying with the guidelines that we're laying out today. That's our rationale for this language as to why instructors can't be proctors.
And I think and this is on page 3, you all, from on 3A 2, asking at a minimum of one proctor is required per course. I can tell you, as past president of Arello, that other states are requiring breaks of up to 35 is one proctor. Over that is another. So every 35 to 50 is a proctor. So if you had 400 people, it's going to be very hard for one proctor to even do that. So to me, I think this is very kind to only require one. I don't know how one could do it, but to again, as Mr. Gwen said, that it would be 0. It would be, that's not doable. Any other comments about it?
I thought at one time we discussed one proctor per 30 people or something.
We have discussed it, but it's not in this rule, is it, Anna? It's just minimum of one. Do we want to put it in the rule? Is it too late to do that?
I think the last time the commission discussed it, it was kind of like, how do you set it? And maybe it should be a business decision.
Yeah, we couldn't.
Well, the business decision is always going to be one proctor.
Right, we couldn't decide when we originally drafted the rules. We decided with just a minimum of one because we couldn't decide the number.
But I can tell you what other states are doing, and I mean, I don't know if anybody's requiring.
Right, we were just like
just
thinking,
one.
Determining, like, I think when part of the discussion came to thinking of larger businesses versus smaller businesses and hiring of proctors, determining, we were thinking 35, but then the number got smaller, and then it just became letting the course instructor or the school make the determination of the proctor.
So this is our time now to do something about this or not.
Boss. So when a course is determined, is there a form or something that's the person says, okay, my proctor for this course is Joe Smith or whoever? Do they have to name the proctor, or is it just assuming that one shows up at the time the course happens, or how does that work as far as, you've got who the instructor is, but you don't know who the proctor is? Maybe. I'm just wondering how that works.
It's just part of this process. When they want to have a synchronous course, they'll send this to me generally several weeks in advance after TREC has approved the course and that they want to put it on synchronously. and they include a short outline. Generally, it's in different formats, but they name the course number, the instructor, name them, provider, a little bit about the course, and then essentially send that to me. And it follows the guidelines that are on our website now that were there back in the day, a year or so ago. So anyway, they do that, and so that information is there before me. And just to add, yes, you do need at least one proctor. If you had a 60 people online, and it's just that it improves the education overall that they're about to receive. So there's that.
Is there training, or how do we know the proctor knows what they're doing? In other words, we vet the teacher or the person giving the course. You vet that person,
right?
But are you vetting the proctor, and do we know that the proctor knows how to proctor?
Generally speaking, there's no vetting process for the proctor. Rather, the industry itself, and the education industry, they will have, and predominantly these are association providers that put these on, so it will be their education director or person that will be the proctor. In other cases, they name someone that's a part of their business and as the proctor, but we don't do any training or vetting of that person.
And I'm fine with that, but do they don't provide the name of the proctor or proctors when they submit all this information to you a few weeks ahead of time?
Yes.
They do?
Yes.
Okay.
The instructor and the proctor, they name them. If they don't, then I get back to them and say, well, who's your proctor?
And how many times do you get more than one name as a proctor?
I don't believe I've ever seen a request with 2 proctors. It's always one proctor.
And can we make that addition? And will you have to read all this back into the record?
Like a rulemaking hearing.
So if we
Like
want to
this would
do that,
be-
then what's the number? Is it 50 instead of 35 to help the smaller businesses?
So for an online meeting, if you got the grid view up, you can see 9 people, a dozen people. You can see more than that. Well, I mean, but at what
I
point?
don't know the number, but I know if you have like a.
It depends on the system, probably.
Because I don't want any proctor to have to move screens and in order to get them to have one screen and have all the participants' faces on there.
And I don't know that we can require that because it would depend on the system that they use.
So
It depends on, like, if you're doing Zoom, what kind of Zoom.
I think you have to think about also if that's all you're doing
expense.
is just.
Right.
Cameron, you've seen other states do one for 35.
35 to 50 is usually somewhere in that number. Either 35 or 50 is usually. Ross is on the Arello certification committee also.
Ross, I mean, would 1 per 50 be sufficient?
It'd be a good guideline, I think.
Now, are we talking about 50? Is that a mix of people who are online or in person, or is that just all online?
All online.
This is all online.
Perspective, are the proctors in the same place? Like, how do they know who's watching? If you've got 60 people on a screen,
proctor could be anywhere.
So you've got 2 different proctors. How is that going to be an advantage if the proctors aren't working together?
They would have to divide out the screens. I'll take screens 1 through 5. You take 6 through 10.
I guess my question is, like, how much of that do we need to micromanage, or how much of that is?
That does not need. We don't need to.
It just gets so complicated if you think, okay, if we want every 35 people, we
don't need to tell
proctor.
them how to do it. I think, though, it is good if we tell them, if we say 1 proctor per 50 people. If there's 100 people, you need 2 proctors.
The way if they want to just have 1 proctor, they'll just do. They'll limit the courses to 50 people, and they'll do more courses.
Right.
Is there? I guess, have many of you taken these synchronous courses, and how many people are typically in a course when you take it?
I've never taken one where there's hundreds that I've known about. I've only seen 40, 50, 60, some odd.
If it gets more than 24, I'd be surprised. 24 to 30.
I
maybe?
was thinking the last time the place that we landed was essentially this is on the provider. If they are having people that are doing the wrong things in the course, they shouldn't be giving them credit for the course. Ann and I are just discussing, I think with a change, not that we can't do a change, we can. It will just have to go back through the governor's office.
But this has not gone to the governor's office yet, has it? It has.
I'm not saying we can't change
the rules
it.
can still be approved. I'm just trying to figure out how many people are typically in a course. So if we're talking about one proctor per 35 or whatever the number is people, are we seeing 70 people in a course? Or are we seeing 50 people in a class?
I think it's all over the board. It just, it all just depends. There's no way of predicting it even.
Maybe the number's 35.
I think we ought to leave it like it is myself. I think the guy's stirred up a hornet's nest a little bit, and he's wanting to go to 0, and we have it at 1, and it's weak. It's what we have in there now is nebulous. We don't have any kind of parameters or anything else. So, we can get into a lot of detailed discussion on what happens when a screen goes out and all these technological things.
We don't want to get
into
that.
We don't want to get into that.
I guess my question is, well, here's another consideration. These are your rules, so of course you get to make your own decisions. With looking at the proctor situation, but also the other guidelines that we have in place as well are pretty stringent in themselves. So if we're looking at Mr. Wisenet's comments as a whole, for example, if we were to look at the next comment, we can look at all of these together. The next comment talks about 1260-05-.183B2, talks about requires 100% attendance for continuing education. So it states it is suggested to include wording similar to or exact of the current classroom attendance requirements found in requirements for courses rules 1260-05-.03D1, allowing an 80% attendance requirement for non-continuous education courses. So he's suggesting D, incorporate appropriate methods for determining whether a student has successfully completed such course. Such methods shall include, but not limited to, 1, minimum attendance requirement of 80%, except that such requirement shall be 100% if the course consists of 8 or fewer classroom hours. So I read that, maybe I'm not reading it correctly, but it seems to say that possibly wanting to get partial credit for attending a distance education course. That is a difference here in the distance education course from a classroom course, in that you are required to attend the whole course. Also, the course requirements for students state that, the camera has to remain unmoving, or that you're not required to participate in any other types of computer-based or non-computer-based work or other while attending the course. So if there is technically one proctor, you should be having one person literally looking at you the whole time. So
and they're going to have to keep up with 80% or 75%?
So I'm saying, at his suggestion, if there's more than one proctor and we were to change the rule to permit partial attendance, or if we were to change rules, there are other comments later you'll see that suggests, to relax the rules regarding cameras being stable or unmoved or any of those other types of requirements. There's like a give and take regarding the proctor situation. I'm saying if we want to look at that, maybe look at the totality of the circumstances regarding all of the rules that are put in place for it, whether we think that is something to consider.
I'm writing each of these things that we have questions about. And so once we get through all of his comments, then we can come back and say, what do we want to do about these? Is that okay with everybody? Okay.
So for which one?
80%. I mean, is he saying that if you take a 10-hour class and you show up 8 hours, you're going to get credit for it because you made the 80%?
So if we look at 1260-0.5-0.03 D1, it talks about non-continuous education courses.
Hey, I'm sorry to interrupt just for a second. This is Countess. I was just trying to let Aaron know that my brokerage, they're on the line now.
We'll get back to you after we finish this rulemaking hearing. So
That's
just hold
perfect.
on.
Thank you.
Yeah, we can't stop in the middle of this. We'll be with you as soon as we can.
What, give me that.
It states, I'm pretty sure he's talking about 1D1. So it states like the applicant shall demonstrate to the commission, to the satisfaction of the commission, that each course submitted for approval will incorporate appropriate methods for determining whether a student has successfully completed such course. Such methods shall include but not limited to. And then the first one states a minimum attendance requirement of 80%, except that such requirement shall be 100% if the course consists of 8 or fewer classroom hours. So 80% requirement is required if the class is more than 8 hours. Is that correct, Ross?
Sorry, say that again.
So if a class is 8 hours or fewer, you are required to attend 100% of your class to get CE credit.
That is correct.
Okay. And so in this comment, Mr. Wiesnant is suggesting to allow something similar to an 80% attendance requirement for non-continuous education courses. So it's stating that we would include a provision that says D, incorporate appropriate methods for determining whether a student has successfully completed such course. It should include but not be limited to a minimum attendance requirement of 80%, except such requirement shall be 100% if the course consists of 8 or fewer classroom hours. So actually he's just talking about we don't have that provision. So if it's a distance education course right now, if it's 8 hours or more, in order for you to get credit, you would have to attend 100% of that course.
Here's the real world on this. In any class, you're going to have 10-minute breaks, bathroom breaks, drink. And so teachers include that in the 20% that they're not teaching. So it only makes sense to me, too. I can't set 8 hours and not have a break. So I think it's, I think he may be right on this one, that it be 80%. And regardless of the hours, really, to me, I mean, if it was a 1 hour, I wouldn't do 80%. But, I mean, if it's If it's 4-hour class, you're going to have a bathroom break.
Well, I think the clarification, so 80% saying we're talking about classes that are 9, 10, 11, 12, whatever class hours. So if you're taking a 10-hour distance education course, in our rules, you have to take all 10 hours in order for you to obtain your CE credit. So in this comment, the suggestion is to include a provision that if you obtain 80% of those 9, 10, 11, 12 CE credits, you would get credit for it for distance education.
So would I get 8 hours or 10 hours? In your hypothetical situation.
In the hypothetical, it would depend on whatever 80% of 9, 10, 11, 12, whatever it is. Right. And I think
those courses are usually over 2 days. They're not usually
right, I think
10 hours all day.
I think the mindset would be for distance education courses for that would be the fact that it's a distance course. I mean, it depends if it would be synchronous or asynchronous.
If it's I don't think that would count. Like if you had to get up and go to the bathroom, I feel like we're talking about two different things.
We wouldn't be talking about that.
We're talking about just if you're not there for 2 hours of the class for some reason.
Right. I think possibly this provision, if we were to include something like that, it would need to maybe have a distinction between synchronous and asynchronous courses, because I don't really see a reason for having a distinction between having 80% of completion for a class that you can stop and start and stop and start.
This also goes to the proctor. I mean, who's keeping up with this 80%?
Right, but that would be a synchronous course.
Right.
But I'm talking about like an asynchronous course, one that you stop and start.
I feel like you should do 100% of an asynchronous course. There's no
Right,
reason to not.
But Mr. Wisenet, what he's saying in this comment is that these rules don't have this provision and that it's something that we should consider adding.
Question. Anna, what do you think his motivation for suggesting this is? I don't understand it. Why the 80%? I mean, is it he's trying to get people to pass more, or you don't have to take the hardest 20%, or how does it work? I mean,
you still have to take a test if it's 8 hours or more.
Well, but if you're,
I don't know. I'm thinking
how does the test
80%
work?
for people that maybe, have an emergency, have to leave, or for some reason can't complete the whole time of the course. But for me, I don't think I included that part of I'm not sure that distance education would be excluded if this is like a requirement for.
So maybe we're willing to leave it as it is then.
So is his suggestion just change the wording so that synchronous is 80% and asynchronous would be 100%, or he just wants everything to be 100%?
Well,
80%?
Too bad he's not here so we could ask him the question. But
no, I'm not sure. I don't understand why that this doesn't apply already. Like for this specifically, this just has the rules for distance education. Like specifically, this specific rule has the requirements for courses. Like I think this applies because distance education courses are still continuing education courses.
So if it's in person, what's the rule?
No, I think it still applies to courses regardless. I don't think we need
whether it's in person or not.
But so I'm asking if it's an in-person class, like
It's
in
still-
the classroom, do you have to have 80% or do you have to have 100%?
it would be 80%. I think it
If over 8 hours.
over 8 hours. I don't think it's needed to add to specifically distance education because, like, for example, this has requirements for courses here, and this has requirements for instructors, and we don't have specific requirements listed in our rules that are special for instructors for distance education. Like, I don't state that you have to have a different diploma for instructors because you don't need one for distance education because we already have those listed in our rules.
But you're saying the rules apply
They
regardless.
apply
Like, we don't
any-
need to specify because there's
Right.
already a rule in place.
Yes, I don't think
Got
it
it.
is necessary.
And I think I agree with that also. Does anybody have any?
I agree also, because my concern is you have to take a final exam if you've got more than 8 hours. Is that correct?
Yes.
So if you've only been in the class for 80%, your chances aren't as great to pass that final exam, which is going to be at the last part of the day, of the second day or the first day. Is that
Right.
correct?
Yes, and the final exam provision's already in there. That part's
Right.
not being changed. So
You don't
like,
have to make 100 to get credit.
You don't
So-
have to make 100, but I would think you don't want to skip out at lunch on that last day either and not take an exam.
I don't think that matters. Like, this part matters. So I don't think it's something we need to change.
I agree with you.
I think we're ready to move on.
Yes, next part talks about paragraph 3C1. It says this paragraph refers to students logging onto the course 20 minutes before the class time. It suggested that this 20-minute login prior to course be changed to 10 minutes with multiple sessions, course such as pre-license or course for new affiliates. 20 minutes prior to each class session is not necessary except for the first class session of course.
I agree with that. Do y'all agree with that? 10 minutes? I don't think I want to log on. So
He said, I want to think about that in just a second.
I think if I'm required to log on 20 minutes beforehand, then I'm going to be somewhere else doing something else during that 20 minutes. So I don't know why I would need to. The only reason for it is to make sure that you had the connection, that you were able to log in. And if not, that would give you time to call and maybe get a new link sent to you or something. I don't know why 20 minutes is necessary.
So his question here is, okay, for the first day or the first login, 20 minutes. But after that, you waive the 20. So if it's like a 3-day course, log in 20 minutes before the first day, and then
No,
the second, third day, 10 minutes?
I think he's saying like the first session of the day. For the first session of, I think if we're going to decrease it, it should just probably be 10 minutes.
No less than that, but 20 is a lot, I think.
You have to be on camera that whole 20 minutes. You just log in,
No, you
and then
just
you got to
log
be on
in.
camera when it starts.
It just says to be on for the first
So
10
logged
minutes. So, I mean, we can decrease it to 15, 13. I mean, it depends. If you want to decrease it, we can. 20.
10 minutes
I'm
is
fine
good.
with 10.
But again, my question is this. If we make this change, then this still has to go back through the process.
In 20 to 10 is not that big of a deal.
Okay. So it can be a small change without starting the process over. Is that what you're
I
saying?
mean, I'm talking about like big, huge substantive changes.
Okay.
We don't want to make those. But if we need
So we're good with 10 minutes. I think
but
everybody
if we
is.
need to make big, huge substantive changes, we can. It just might mean the rules might take a little bit longer. So keep that in mind when we're going through them because we want to make sure that the rules are correct. It just might take extra time.
Oh, and to that, the process, to me, it seems like it's not as lengthy as it used to be. We started this process when, Anna?
I have no idea.
Well, you voted. I think you voted on these rules in June.
Okay, so
I can't remember. So this also is a result of a legislative change to the law, which broke out asynchronous and synchronous. So that happened, during
year.
this session.
Yeah.
And then this is in response to that. And I think Anna had drafted the rules in June. We discussed the rules then. And then
But a lot of times it takes a year to get a rule in place. So this one's moving expeditiously, which is what we want. Okay, so 10 minutes. So we're ready for number 5.
Number 5, it refers to paragraph 3C2. It says this paragraph refers to the verification of a student's identity to start time. It is suggested that this student identity verification only be required for the first class session and prior to the administering of a final examination. It is suggested that identity verification not be required to each session of a multiple session course, such as pre-license, course for new affiliates, and office and broker management.
Comments from the commission?
What are the steps to verifying identity? You just show your driver's license?
So it says, for the rule, it says proctors and or instructors must verify the identification of each student with a state or federal issued method of photo identification prior to the notice start time. So to me, that says show a driver's license.
Do you think that requires, like, I don't know if it's worth a change if that, like, if it's a 2-day course, that does that necessarily mean that you have to do it both days? I think that's his concern.
Well, the problem too is, can I send my assistant go sit in that class for me?
That's exactly what I was thinking.
Yeah.
I say stick with the show your ID
Yeah.
both login days. I mean, is
So
that how much of a hardship would
I
that
don't
be?
think it's difficult to show a
I don't
driver's
either.
license and to check it, but that's me.
I say
that.
leave it like it is.
Okay, I think we have consensus to leave it like it is.
Paragraph 3D1. This paragraph refers to student being visible on camera. It is suggested that the student's full face be plainly visible while on camera in a standing or seated upright position. Some students will only want to display the tops of their heads or be in shadows. In addition, we have had students wanting to take the entire course while lying in bed.
Well, get up. I mean,
I don't change it.
we're not changing that.
If you're in the class, you don't want to be looking at somebody's forehead laying in bed.
Well, my daughter, when she got her license 3 years ago, she would send me pictures from her class of people totally asleep with their heads down, but they were there. So, and they got credit. So, this is a convenience that we're offering to be able to do classes this way. So, yeah, I don't think anybody's wants to change that one. So we can go to the next one.
I got a question, though.
Okay.
On D1, Anna, it says the student must be visible on the camera at all times, but it doesn't say what happens if you start out visible and something happens and then you're not visible.
Your proctor's writing it down and keeping up with how much.
Well, but I
you're
mean,
off.
what if they say my camera went out or it doesn't?
That's
That's an
their
emergency.
problem.
Well, that's it. I
mean,
think it specifies that if that were to occur, the student would
To notify the proctor.
through the chat that's available
Yeah.
in the
The
software.
camera went out?
Yeah. So, or an emergency situation arises. I guess a camera going out would be that.
Okay.
Okay.
3D2. This paragraph refers to the student camera being stable and unmoved. Sometimes students will move their computer during a class. The above requirement seems to be overly burdensome to the student and not practical requirement, especially for a multiple session course such as pre-license and course for new affiliates.
Comments on that one? We're ready for the next. Okay.
I mean, I'd like him to explain what the burden is.
Yeah.
I think it's probably whether somebody's on a desktop or a laptop.
Or an iPad
Or an
holding it.
iPad.
I mean,
Commissioner Ferris, if you could speak in your microphone, please.
Thank you, Council. I think as I recall, Council, the discussion was about a course attendee not driving.
I remember that now.
So I'd say leave it alone.
We have a consensus.
I can't
to leave that
imagine
one
a
alone?
proctor's gonna ding somebody if they scoot their camera from like here to here.
Walking like
Okay.
Mr. Ferris.
Ready for the next one, y'all?
Okay. 3D3. This paragraph refers to students not participating in non-coursework while attending the course. Based on past experience, it is suggested that the wording needs to be more specific to include such suggestions as no texting, no telephone calls, no email, no conversation with other people in the student's room.
Or what about just scrolling Facebook, Pinterest? I mean, people do that. I mean,
I think all the things he listed can be included in non-course work.
yeah, non-coursework, period, is a good cover-all.
Doesn't need to be changed. The proctor can prompt somebody to say, hey, what are you doing? You know, have to put that on the proctor and instructor.
You can't see their screens, right? So it's just looking at them through the face front camera. So you're not monitoring what's on somebody's screen, or is it mirroring people's screens? Like, how are they going to know if somebody looks like they're paying attention? They're scrolling
Here's
Facebook.
what you do is this right here. You know, this is what you do. So you just need a blanket statement. Don't do it.
Yeah,
and if they mess up and come up or still reading it, then
I don't want to see.
Yeah, they're still going to do it. So we can just have a statement to not do it, but they're still doing it.
Right. People speed.
We do the best we can.
Well, and I think somewhere in this rule, Anna, that there's a discretion of the commission for guidance or things like that. So if it gets out into the real world and some of these provisions need to be modified a little bit, then we can issue a guidance. So I think a lot of.
I mean, if you just take a look at this room, you know there are people that are on their phones. You know they are. So, I mean, it's going to happen. It happens. I do it. I mean, you know, it is what it is. So I think we want to leave this one alone. Is that correct? All right. All right. Next.
3D4. This paragraph refers to students not leaving the camera, and if an emergency arises, students should notify the proctor privately. This is a very restrictive requirement, especially in a 60-hour and 30-hour course. Sometimes students will need to take a few minutes off camera for a short period of time, such as going to the bathroom before a scheduled break.
That's the case. They have the option to message the proctor, right?
Right.
Is there any consideration in the rules, either this rule or other rules, for like a suggested break time for a certain number of hours of courses, number of hours in a course?
I think isn't it 10 per hour or something? There's something
It's
about 50 minutes per 50 minutes of instruction.
And the instructor will ask, you know, do we want to keep going so they can take a longer lunch or, you know, whatever usually is what happens.
So I mean, the rules already incorporate periodic breaks during a course anyway.
Yes.
And I don't think anybody expects a student to be on camera when they're in the restroom. So,
please.
Because I don't want to know.
All right, next.
3E1. This paragraph refers to schools maintaining a recording of the synchronous course. In this proposed rule, there is no stated time limit as to how long to keep the recorded classes. Since license law requires brokers to maintain records for 3 years, this seems a reasonable time period for the maintenance of recorded classes by schools or associations.
I think that sounds okay to me. Do we want to add that then?
Well, I mean, we're not talking about VHS tapes here. We're talking about digital files. They're usually software provider, download.
How long do our meetings stay online on the state website? Are they forever? You can go look at our meetings, or there's a time frame?
We have them on YouTube, so they're
Forever.
on there.
Okay.
for a long time, but we have like a records disposition authority act, so they're required for at least 7 years, but that's by our statute. So
And our firm rules are 3 years. So he's just wanting us to be more specific, I think, by this. Do we want to add 3 years, or do we need to add 3 years?
I think
I guess the question is going to be is how far are we going to look back if there's a compliance issue? What's the window?
Statute of limitations.
So what's the estimate?
I thought there was some period we talked about 2 renewal cycles based on like the broker 120 hours. Was that? Uh-huh.
I couldn't hear you, Mr. White.
I think we agreed with what Victor Maxwell was talking about unofficially, the time period. We didn't.
When you say 2 renewal cycles, it would be 1 cycle and then
It's 4 years.
the next renewal cycle. So that would be 2. And is it
Renewal
4
cycles are 2 years.
Right. So you get you get renewed. That's the first renewal. And then the next renewal would be your second. So it conceivably be 3 years.
I would recommend putting a year requirement in case renewal cycle periods change in the future.
Good idea. So
But
we
to
want to
keep
make
track of.
Do
I
we want to
think.
make it 3 years then, or
did you say 1 year or 3 years?
I don't have. Our records requirements are 3 years, but if we're talking right now, renewal cycles for courses are 2 years, so that's 4. So, do we want to do 4 years?
that's
Sure.
plenty?
I like 4.
Yeah.
Right, we're in agreement to 4 then. Brooke,
Number 11, number 5 states any course providing more than 8 hours of continuing education shall include a final examination which shall be executed prior to the submission to the Commission for Education Credit. So this paragraph does not give any guidelines as to the final examination testing procedures. For courses greater than 8 hours, a final examination is required to be submitted for course approved by the Commission as part of the course approval procedure. In the past, there have been complications in administering of synchronous final examinations, especially from a final examination security standpoint. If a final exam is mailed to the student, the examination can be lost in the mail, or the student could cheat by secretly opening the final examination prior to final examination administration by the instructor/proctor. And returning the final examination, it can be lost in the mail. Also, the student could copy the final examination. Since the course is taught synchronously, it is suggested that the final examination should be administered and graded synchronously online. This ensures the security of the final examination integrity and removes any human error in grading. TREES has successfully administering a secure synchronous online final examination procedure for the past 18 months with excellent security and student satisfaction. This program allows an instructor to synchronously monitor in real time via Zoom the student taking a secure online final examination with automatic computer grading. In the absence of synchronous online final examinations, stringent procedures should be enacted to guard the security of the final examination. If not, the purpose of a final examination is moot.
Well, I totally agree with that. I guess my question is, he has a large company that's been in business for 47 years. He has the, the equipment needed to do that. I'm thinking about some of these classes that we get that, that may only have 2 or 3 classes a year, how that could be a little cost prohibitive to them. So we might get a little kickback on that. So Not kickback, but pushback. I shouldn't say that word in this building.
Be clear, yeah.
So what do you think? What do you all think? He's exactly right about though keeping those exams secure.
I think you ought to.
It seems to me from his comment that there's some type of tool inside of Zoom or whatever for them to conduct an exam securely.
And I don't know because I've not ever done it. Have any of you all done that? An online exam like that?
Ross, what do you have any thoughts on this with the secure testing?
Asynchronous.
In the past, Commissioner, we've talked about it, but you know, we left out any formal description of how that could be done. And one thing is, once they give these exams, we don't get the response here. We don't get the exam grading or any of that. They handle that exclusively.
The inspector, excuse me, the instructor tells.
It's a pass fail.
Yeah, they tell us who passes, who fails. They tell you, I mean, or.
Well, it'll go to CE broker.
Yeah, right. Yeah,
that's correct. So there hasn't been a lot of discussion about stringent procedures, but I think, you know, just in my opinion, he makes a good point here with the way that they're handling it.
And this kind of, I'm sorry, excuse me, Steve. This kind of examination that he's speaking of, it's not handled elsewhere in the rules.
No, that's how it was written in the rules previously. We did not have specific guidelines as we don't record that information. It's been left to the course providers in the schools to administer and govern on their own.
A guard against.
Also, we don't want to get too specific on the different platforms because not everybody may use Zoom to administer their courses. So I think that's another consideration we should take. And using, while trees may use Zoom, someone else may use WebEx, Microsoft Teams, or something else. So that's something else to consider.
I appreciate his concern over this issue. And it seems like he's got a secure thing that works. However, he points out that there's mailing going. Ross, does that concern you? If that, and there's, you know, it says if a final exam is mailed to the student, the examination can be lost in the mail. It sounds like there's people out there that are mailing a test and then the answers are being mailed back. Is that correct? Or
that would be mailing back to them.
Right.
We're never getting the mail.
Correct.
But you.
Right. No, I'm not concerned about us. I'm talking about the course is set up in a way that when it ends,
you could get the test beforehand and keep that test with you while you were taking the class to be able to fill out the answers, or I can make a copy of it and you take the class tomorrow.
Well, I think what he's talking about is the exam is mailed and the class ends and they say, oh, okay, we're going to mail you your test. That's what it sounds to me like. And then they take the test on their own time after they get it in the mail. Could that be right?
I'll just say that it's possible since the commission has not enacted stringent handling procedures, and the last time we discussed this at length, then that was not done. It was left as is. So the provider has a lot of responsibility to maintain the integrity of this test. Now, if they can do that and mail it to them, that's that sounds iffy.
Correct.
But we also live in a state where not every piece of the state has internet yet.
I know it, but if you're taking a online course and at the end of the course, you're saying, I'm going to mail you a test and you can mail it back. You know, it's a 3-day deal back and forth, easy. That defeats the whole purpose of the course.
How often do you see that? Like, do you know how the exams are done? Is it common that people are mailing a test,
I have
or is
not
this a
heard that.
very unusual?
I
It should
think
be in
that-
the syllabus.
I think the comment is well taken. That could be happening, but I haven't had a complaint or any issue come before us about that.
I don't know why anybody would even do that. It seems like it would be very burdensome on the instructor to do that. It just, I can't imagine this situation happening in 2022.
I agree with you, Commissioner. What I'm thinking is, though, under the paper and pencil correspondent format, then you could well have that back and forth, and that's one of our formats. And paper and pencil is included under distance education as well, but it is separate from this discussion about synchronous and asynchronous.
Yeah, I'm recalling all of the online tests that I have done were for asynchronous courses.
Fine, I would just.
Right,
Online
and
test?
it's
Yeah, but
immediately
you
when
can
the
log
exams.
in, log out, log in. You take a quiz, and then you'll take a final exam. And if anything, I'm for leaving this alone for now.
Until we see a problem.
Until we see a problem, but this might just make people do 7-hour courses. Keep from having to do a final exam.
I would say the burden is on the instructor and not on us.
All right, so we want to leave this one alone then, also?
Yeah, I mean, Ross, if you
Or
start
you want
hearing
it
about
changed?
Mr. Bill has got far more experience in education than I do, so I'm not going to say, hey, I just am. What do y'all think? But if anybody,
Oh, he's great.
yeah,
He's great.
he's
and
a
he's
pros
on top
pro,
of things.
right?
Yeah,
Absolutely.
I appreciate him.
Yeah.
With having the
It's
suggestion
very-
and bringing it up to
It's
us.
very thorough to think
Yes.
of all that
It
could happen.
sounds
I
like-
just don't
yeah.
know that we want to deal with all the what could happens if they don't normally.
Right.
Want to make a change, or we want to move on?
I want to move on.
I'll move on.
I think we're ready to move to number 12, Anna.
We suggest that there be a provision in the rules that gives the instructor some specific authority to carry out these rules with students violating the rules.
Well, if it's in a rule, it's. I mean,
But the problem with discretion is that it can be applied unevenly. One instructor could do.
Do they not already have discretion, the proctor and the instructor, when they're watching? I
Yeah,
mean,
they probably take it, even though they don't really have it. But
Very vague. Sure. Discretion instructors need from.
I think we need.
okay, let's move on to number 13.
Thank you on behalf of Trees, Real Estate, school instructors, and staff. I want to thank you all of the commissioners and staff for giving our suggestions consideration in this very important rulemaking hearing. Does the commission have any further comments related to the information and comments provided by Mr. Weissman?
I'd like to put on the record, thank him for providing these remarks, sharing of his experience. He, in my opinion, Trees is a gold standard for education in the state, and instructors would do well by seeing how they run their shop and how they provide courses, be it online or in person. And I hope that Trees can continue to provide education for Tennesseans for a long time.
With that, I do want to circle back though. I wrote down two things: number of proctors and attendance. Do we want to do anything about number of proctors, or it's now one person? So do we want to increase that, or do you want to leave it?
What do other states do?
Other states, most of them do 35 to 50 is one proctor. If you've got 60, you'd need 2 proctors.
So less than 35, no proctors?
No, you got to have one for the 1 through 35. You're required to have
Okay.
a proctor.
Some states have one proctor for 50 students. Is what you're saying?
Right.
Yeah.
Right. So if we want to err on the number side, maybe we would go 50 instead of the 35. I want to make the comment too here is that, and I may have said it before, but some states, for instance, Alabama, has 11 people on staff for the education department. So, you know, Ross has to do this all by himself. And so, you know, I don't want to put more on him than he can handle. But I think what's going to help, though, is to have a rule about the proctors and the number of proctors.
I have a question. So I have 48 people signed up 5 days before I send it to Ross, and I have my one proctor lined up. The day before, 3 people sign up. I have 51. I can't find another proctor. What happens?
Get your administrative assistant to come in there and be a proctor. You get somebody. I mean, this is not it doesn't take a law degree to watch a screen. Count the people, see the faces.
Here we were concerned about the credibility of the proctors.
I know, but I mean, it's not. I mean, it's basic what the proctor has to do.
I mean, I'm not disagreeing. I'm just saying, are we going to penalize them?
Well,
they bounced over the number there the last minute or something, or
if anybody knows that people break rules, it's this commission, and we know that people will take it to that. Well, I've got 54. Is that okay? You know, I'm, and we're all different personalities. I'm a black and white person, though, and if it's a rule, it's a rule, and it's enforceable. You know. And some people are not as strict as I am about that thing. So that's why we have 9 people to vote on it.
So with that, what you've said, since it's a rule and it's enforceable, they break the rule, what happens?
They could file a complaint.
I personally think we ought to leave it like it is. He's wanting to go 0, and we have 1 in there, and I think we just leave it at 1, and it's got some because I think the proctor, it sounds like it's doing more than watching a screen, because they have to communicate potentially with people during the course when things happen, whether they be technology or other things. So
are we okay with the 1 that we have and not change it? Okay, that seems to be the consensus.
Well, and plus the language is at a minimum.
At a minimum.
So
and
there's the possibility for them to have the discretion to have 5.
Right.
That's right. And in associations like Greater Nashville Realtors, the ones I have taken, there have been 2 that I've seen that come to my mind in recent memory.
I say leave it.
Okay, and so there's nothing else to be said about the attendance. Leave the attendance as it is. Okay, I think we're done with that one.
Okay. Are there any comments from any members of the public today?
Quick. You need to state your name, sir. Okay. His name is Anthony Willoughby. Okay.
I don't see any comments from the Microsoft Teams, so I will need a motion to adopt the hearing rules as amended. We only have 2 amendments The first amendment is to 1260-05-0.18.
Which one are you on?
One
Distance.
C1. It will now state students must log in and or check in for class a minimum of 10 minutes prior to the notice class start time. There is also an amendment to 1260-05-0.18, distance education to paragraph, sorry, that was 3 to paragraph 3E1. Providers must maintain a recording of the electronically streamed course for 4 years.
Yes.
So I will need a motion to adopt the hearing rules language for R and Regs 1260-005-0.11 correspondence courses and new rule 10 Comp R and Regs 1260-005-0.18 distance education.
Would anyone like to make that motion?
So move.
Second.
Okay, so I have a motion by DJ Ferris and a second by Ms. Smith that those be approved as stated.
I will.
Okay.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffitt,
Yes.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Commissioner Kathy Tucker,
Yes.
Chair Marcia Franks.
Yes.
I will now need a motion to approve the rule to adopt the hearing rule language for Rule 10 Comp R and Regs 1260-06-0.04 disclosure of rescission rights.
So moved.
Second. Wait.
Yeah. Okay. So I have a motion by Mr. Diaz, and who made the second? By Mr. Moffitt. Now, we haven't discussed this because there were no comments. Did anybody have any discussion about? Do you understand what we're doing here? We're giving them more time to rescind their contracts on timeshares.
I've got a question.
Yes, sorry, go ahead.
What? So in B, this is more. It says every contract for the sale of a timeshare interval. Is timeshare interval a defined term? So I see it under 1 that timeshare interval is capitalized, but it's not in B. Is it the same thing? You see what I'm saying?
Good catch. Everybody understands though what this rule
Yes,
change is, correct?
Timeshare interval is a statutory term. It means a timeshare estate or a timeshare use.
So
And
that should be capitalized in B, should it not, or no?
so in B, there should be a hyphen between timeshare. So it should say every contract for the sale of a time hyphen share interval. It doesn't necessarily need to be capitalized. So the capitalization that you see in number 1
Right.
is how it's written in the contract. I didn't necessarily do that capitalization, but if you look at it, like everything is capitalized
except for that
except at where?
in B.
1B.
Where in 1B?
Every contract, at least the way the printout I've got is in B, every contract for the sale of a timeshare interval is written as one word in small letters. So when I see a contract and that's capitalized, I know it's a defined term.
Right. No. So I'm stating that I need to change that
Yes.
To
put,
uppercase.
to
Yes.
no, not to uppercase. Just put a hyphen between the timeshare, the term timeshare.
Steve, if you look at that paragraph, the beginning of every word is capitalized.
I know it. It's not there. I'm just. It's a minor drafting thing.
Right. I mean, if you look at, are you talking about like 1B1?
I'm talking about 1B.
Yes. 1B.
1B, to me, to be consistent and not.
Right. For every word in 1B1 is capitalized. And that's taken off of the contract. And the only word in 1B that's capitalized is the E in every.
Okay.
I think we should defer to Miss Matlock since she's our attorney's wisdom.
Is that making? Is it?
Yeah, it just seemed like it would be clearer to me, but whatever. If you add the hyphen in there, it's good enough.
Okay.
All right, so we have a motion by Commissioner Diaz and a second by Commissioner Moffitt to approve this with the exception of a hyphen. Are we ready to vote?
Are there any discussion from any members online or in the public?
There was none, was there?
Just offering. Wow.
There you go.
While we're here. I did too. Hearing none.
This one also needs a roll call vote, so I will be doing that.
Do we need to open it up to any? Okay. All right, so we're ready for the roll call vote then.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffitt,
Yes.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torvett,
Yes.
Commissioner Kathy Tucker,
Yes.
Chair Marcia Franks.
Yes. Motion carries unanimously.
And lastly, there are several measures I will need to read into the record for the rulemaking filing form. So next, I will read the regulatory flexibility addendum. Yes, you'll see. So for each of these, I will be starting with the timeshare rescission rights rules, and then I will be proceeding to the distance education rules. And so I will start with, we're beginning on page 5. Pursuant to TCA sections 4-5-401 through 4-5-404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small business. 1, the type of or types of small business, and an identification and estimate of the number of small businesses subject to the rule being proposed. that would bear the cost of or directly benefit from the rule being proposed. The rule amendments do not affect small businesses. The Commission does not foresee small businesses to bear costs to comply with the rules. The rules are intended to provide consumers their updated rescission rights for timeshare interval purchase contracts. Most timeshare interval companies are not small businesses, but should any timeshare interval companies be categorized as such, the Commission does not foresee any cost or negative impact. 2. The projected reporting, record keeping, and other administrative costs required for compliance with the rule being proposed, including the type of professional skills necessary for preparation of the report or record. The Commission does not foresee a cost for the administration and enforcement of the rule amendments. 3. A statement of the probable effect on impacted small businesses and consumers. The rule amendments do not affect small businesses directly. It is anticipated that these rule changes have a positive impact on consumers, as the rule amendments add an additional method of rescission of contracts to purchase timeshare intervals. 4. A description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the rule being proposed that may exist, and to what extent the alternative means might be less burdensome to small business. The Commission knows of no other less restrictive of burdensome means than through the promulgation of these rules as amended. 5. A comparison of the rule being proposed with any federal or state counterparts, and these rule amendments may be like current or proposed rules and regulations in other state-level jurisdictions that regulate the timeshare industry. The Commission is unaware of any existing or similar proposed federal rules related to the timeshare industry. 6. Analysis of the effect of the possible exemption of small businesses from any part of the requirements contained in the rule being proposed. The Commission does not foresee the need for a possible exemption of the requirements and the proposed rules for small businesses. The proposed rules do not impact small businesses nor create additional costs. Therefore, an exemption for small businesses would not be beneficial. I will now need a motion to adopt the regulatory flexibility addendum.
Right, we have a motion by Commissioner Diaz and a second by Mr. Begley to approve these statements. Are we ready to vote, or do you have any discussion?
Is that a roll call?
All right. All those in favor say aye.
Aye.
All those opposed? That motion carries unanimously.
Next, I will read the regulatory flexibility addendum for the rule amendments related to 10 Comp RN Regs 1260-05-.11 correspondence courses and 1260-05-.18 distance education. Regulatory flexibility addendum. 7. The type or types of small business and an identification and estimate of the number of small businesses subject to the rule being proposed that would bear the cost of or directly benefit from the rule being proposed. The Commission does not foresee small businesses bearing significant costs to comply with the rule amendments. As these rule amendments are specifically designed for distance education, this may allow small businesses to expand their business across the state of Tennessee, especially if their business location was otherwise primarily available to licensees living in a particular area, such as a rural part of Tennessee. Additionally, distance education courses may reduce the amount of costs associated with traditional in-person courses that otherwise may be costly to those smaller businesses with less customers and less frequent offerings. The projected reporting, record keeping, and other administrative costs required for compliance with the rule being proposed, including the type of professional skills necessary for preparation of the report or record. The Department does not foresee a cost for the administration and enforcement of these rule amendments. A statement of the probable effect of impacted small businesses and consumers. The Commission does not foresee a significant impact on small businesses with these rule amendments. If anything, the rule amendments may be beneficial to small businesses and consumers alike, as Distance education courses may increase the types of courses, number of course providers, and numbers of courses offered and provided to licensees. A description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the rule being proposed that may exist, and to what extent the alternative might be less burdensome to small business. The Commission knows of no less restrictive or burdensome means than through the promulgation of these rules as amended. Comparison of the state counter. Rules and regulations for the real estate commissions across the country vary. However, it is very likely the rule amendments are like current or proposed rules and regulations, state jurisdiction, federal regulations. Analysis of the effect of a possible exemption of small businesses from any or all or any part of the requirements contained in the rule being proposed. The Commission does not foresee the need for a possible exemption of the requirements in the proposed rule amendments for small businesses. The promulgation of these rule amendments may allow small businesses to expand their business across the state of Tennessee through distance education. Therefore, an exemption for small businesses would. I will now need.
So moved.
All right, I have a motion by Commissioner Diaz and a second by Commissioner Smith that these be approved. Is there any discussion? All those in favor say aye.
Aye.
All those opposed? Motion carries unanimously.
I will now read the impact on local government statement pursuant to TCA Section 4-5-228 for the amendments related to the 10 Comp R and Regs 1260-06-04. Disclosure of rescission rights. The Tennessee Real Estate Commission foresees no impact on any local governments. I will now need a motion to adopt the impact on local government statement.
Moved.
I have a motion by Mr. Diaz and a second by Ms. Tolbert. Any discussion? All those in favor say aye.
Aye.
All those opposed? Motion carries unanimously.
I will now read the impact on local government statement pursuant to TCA Section 4-5-228 for the amendments related to 10 Cop R and Regs 1260-05-.11 correspondence courses and 1260-05-.18 distance education. The Tennessee Real Estate Commission foresees no impact on any local governments.
So moved.
All right, we have a motion by Mr. Diaz and a second by Mr. Begley. Any discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously.
I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies required upon filing a rule must submit the following pursuant to TCA Section 4-5-226I1 for rule amendments related to 10 Comp R in Regs 1260-06-0.04 disclosure of rescission rights. A brief summary of the rule and description of all relevant changes and previous regulations effectuated by such rule. Proposed rule amendment update the every contract for sale share of a amendments clearly number the three added third email. Lastly, the proposed rule amendment provide the disclosure of exactly as written, which will create conspicuous attention. A citation to and brief description of any federal law, regulation, or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. Governor Bill Lee signed Public Chapter 835 into law on April 19, 2022. Following its passage, these rules were necessary to reflect the statutory amendments passed by the Assembly. There is no known mandate promulgation of such rule establishing relevant C identifications directly or those persons urge adoption as well as applicants, members of as well as consumer protection-based groups, to be proponents of the rule amendments as timeshare intervals and contract rescission rights are topics of consumer education and awareness. The Commission does not foresee a particular segment of opponents to these rule amendments. D. Identification of any opinions of the Attorney General and Reporter in any judicial ruling that directly relates to the rule or necessity to promulgate the rule. There are no known opinions of the Attorney General and Reporter or any judicial ruling. E. An estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. There is no foreseeable probable increase or decrease in state and local government revenues and expenditures resulting from the promulgation of this rule. F, G, and H ask for contact information for individuals with information on the rules. I provided my information, as well as Caitlin, and there's no additional information required for this rule. I'll need a motion to.
So moved.
Second over here. All right, so we have a motion by Mr. Diaz and a second by Mr. Ferris. Any discussion? All those in favor say aye.
Aye.
Any opposed say no. That motion carries unanimously.
There. I will now read the answers to questions required by the Joint Government Operations Committee. All agencies, upon filing a rule, must submit the following pursuant to TCA Section 4-5-226I1. Rule amendments related to 10 Comp R and Regs 1260-05-.11 correspondence courses and 1260-CO5-.18 distance education. A brief summary of the rule and description of all relevant changes and previous regulations effectuated by such rule. The proposed rule amendments update requirements and guidelines for distance education courses. The rule amendments include specifying the regulations related to printed course materials or asynchronous courses and general additional requirements for licensees to obtain credit for distance education courses. Additionally, new guidelines for students, course providers, and course instructors are created for synchronous distance education courses. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. Governor Bill Lee signed Public Chapter 753 into law on March 28, 2022. Following its passage, these rules were necessary to reflect the statutory amendments passed by the General Assembly. There is no known federal law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. C, identification of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of these rules. The rule amendments impact current and future real estate licensees, course instructors, and course providers. The Commission expects current and future licensees, course instructors, and course providers to be proponents of the rule amendments, as distance education courses allow an expansion of offerings. This will allow licensees, course providers, and course instructors more flexibility and access to learning. The Commission does not foresee a particular segment of opponents to these rule amendments. D, identification of any opinions of the Attorney General and Reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. There are no known opinions of the Attorney General and Reporter or any judicial rulings that directly relate to this rule. E, an estimate of the probable increase or decrease in state and local government revenues and expenditures of the probable increase or decrease in state and local government any resulting from the promulgation of the rule and assumptions and reasoning upon which the estimate is based. An agency shall not state the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. There is no foreseeable probable increase or decrease in state and local government revenues and expenditures resulting from the promulgation of this rule. FGH ask for contact information for individuals with substantial knowledge on the rules. I provided myself and Caitlin with information, and there's no additional information. I'll need a motion to adopt additional information for the Joint Government Operations Committee.
Moved.
A motion from Commissioner Diaz and a second from Commissioner Moffitt that we approve these statements. All those in favor?
Aye.
Any opposed? That carries unanimously.
That concludes this rulemaking hearing. Following this hearing, the rules will be put on the rulemaking filing form SS 7039, submitted to the Governor's Office for final review, and then submitted to the Attorney General's Office for review and approval. Once the Attorney General's signature is obtained, these rules are filed with the Secretary of State and generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Thank you for being here today.
Thank you, Anna. All right, that concludes the rulemaking hearing. At this time, first of all, I want to thank everybody that's here. We're going to take a break. We're going to take a 15-minute break and be back at 11:15. If anyone is here to get the 8 hours of continuing education credits, make sure that you have signed in back there, and then you'll need to come back. This is not going to take us 8 hours today, so you're on a good day. So I just want to make sure that you're signed in. So everyone, please, let's start promptly at 11:15, please.
Good job, man.
I'd now like to read the A's out of the yellow pages. Abigail Andrews.
Watching grass grow, right?
Yeah, I've been through.
Okay, everyone, we're going to get started. Our next item is an informal appearance by Mr. Anthony Willoughby. And before we start this, I guess I'm needing to know what Mr. Willoughby is here for. Do you have anything that you need to read into the record or anything?
Mr. Willoughby reached out and asked to appear before the commission. I believe, without speaking for Mr. Willoughby, I believe it's potentially about upgrading to a broker.
Okay. Can you tell me when he got his affiliate license?
Yes, he obtained his affiliate license in August of 2021.
Okay, and so to sit for the broker exam, you have to have 3 years as an affiliate. Is that correct?
Correct.
Okay, so that's only 1 year?
1 year and 2 months. Or
So
1 year and a couple.
I'm just wondering, is it in our purview to hear the request? I'm asking our attorney.
First, I think the statute is pretty clear about the upgrade process for affiliate to broker for 3 years.
Okay, so I'm just wondering, do we even have any purview to even hear it? I want to let him speak, but we're just wondering. I don't think we have the authority when statute is clear about it. Why don't I do this? Mr. Willoughby, if you'll come to the mic, I'm going to let you. I don't want to rehash what happened in the past, but if you've got some reason that you think that we should allow you to sit for a broker's exam after you've been an affiliate for 1 year, and I know, we all know that you were a principal broker before. So if you could, you could sum up to us what you're wanting, why you think you should have an exception.
Well, yes. First of all,
His speaker's not on. Your speaker's not on. It should light up red. There you go.
Yeah,
there you go.
Can you hear me now?
Yes.
Got it.
Yes.
Got it. First, I want to thank this commission board, commission chair, vice chair, and every one of you listen to me here for a moment. Now, actually, Ms. Maxwell did allude to kind of why I'm here, but that's not my request. That was not my request, but it's along that same subject. And if I may give you my request.
Yes, just tell us what your request is.
My request here today is to, you say you don't want to rehash it. Is everyone here familiar with me and my situation and why I have come before you? How many people have been here for the last few years?
Everyone was given your revocation information, the order that you signed. And then after that, you came before us and asked for an affiliate license, and it was granted. Correct?
Not correct. But I did receive the affiliate's license as a result of Bobby
What was incorrect
Woods.
about that?
You mentioned that I came before the board and asked for an affiliate's license. I came before the board to ask for a reinstatement of my broker's license as stated in the court order, as recommended by Chairman John Grease, who stood before this board. You were here to make a motion to fully reinstate Anthony Willoughby as a result of the court order stating there's been no misappropriation of funds on behalf of Mr. Willoughby, et cetera, et cetera, et cetera. He was very adamant about that. You were here. He made that motion and seconded that motion. I think it was shorted by one vote, but basically he also stated in his statement that this board has full right by law, being that there is a court order. I understand that Ms. Maxwell she and I talked a little bit about the protocol. Of course, I've been a principal broker. I know the protocol of doing that, but I fully stand, yield to that, because that is the way it works normally. But being that I have a court order signed by the commissioner at that time and the attorney general, that I have the right for reinstatement, not to retest. I think Commissioner Bobby Woods recommended, hey, just go retest and start there, come back in a year.
Do we have a copy of that? What he's saying?
Basically,
he's saying he says he has the right to be reinstated.
That's according to Chairman Reese's investigation. And he made, that's in the records, he made that.
He made no investigation. It was just before us.
First of all, okay, so Mr. Willoughby, I would like to talk about the court order, the agreed order that you're talking about. Stipulated conclusions of law. Paragraph 28. It states, the respondent's acts and conduct as described in the foregoing allegations of fact constitute a violation of Tennessee Code Annotated Section 62-13-312B5, which states the Commission shall have the power to refuse a license for cause or suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of 5, failing within a reasonable time to account for or to remit any monies coming into the licensee's possession possession that belonged to others.
And you agreed to that. You signed that. Correct, Ms. Matlock?
His attorney signed.
Yes.
And
It's signed by Mr. Willoughby and his attorney.
okay, so that was the revocation of his
No,
license.
so his license, he signed, it was voluntarily surrendered.
Okay, voluntary surrender.
So it states in paragraph 29 that respondent shall voluntarily surrender his real estate license number 217964 without prejudice to his right to reapply for reinstatement in the future.
Reinstatement meaning testing again, or reinstatement of his license?
So it states reinstatement in the future. It does not state specifically what that means. So that's been part of the issue of what we have had over the past couple of years. And I'd like to state that it says prejudice to his right to apply for reinstatement.
Well, it's at our discretion.
And so when we're talking about funds, there is a stipulation that he agreed to here that he failed within a reasonable time to account for remit monies coming into the possession for others that belong to others. And at the beginning, so when we have this conversation and we're stating on the record that there was not a finding with any funds that were not made from others, that is patently incorrect. And when we are talking about this agreed order, let's begin with the beginning that we are speaking about 5 specific complaints. So when we're talking about this, let's make sure that the facts are correct and that Chairman Grease did not have an investigation. We had conversations when you appeared informally before this commission. No investigation took place. We have no documents related to that. We're not going to rehash things that did not occur.
Counsel, I think the other question that I have is that there were other parts of the consent order that in the decade or so that has happened between then and now have not been fulfilled. There was a question about a fine or restitution, I believe.
No, so the agreed order is done. Everything has been satisfied with the agreed order. So what has happened to this point is Mr. Willoughby has appeared before this commission to obtain his license, and he sought to obtain his broker's license. The commission declined to give his broker license, and instead he was permitted to apply or give the opportunity to get his affiliate broker's license.
That conversation and that reinstatement was a year and a few months ago in Jackson.
That is when Mr. Willoughby's license was granted. That is not when the commission, I'm not sure exactly when the date of the commission made the motion.
And so his license was surrendered, that went away.
So
And
when
we
his
granted
license was
him-
voluntarily surrendered, so this agreed order has a stamp of 11/18/2018.
And so he came before us for an informal appearance
There have been several appearances.
to ask us to reinstate his broker license, and we said no, but we will allow you to get a license, but it will be an affiliate broker license. And so he obtained that affiliate broker's license in August of 2021. Correct?
Correct. And the meeting was on March 11th, 2020, that the commission approved Mr. Willoughby to proceed with getting his affiliate broker's license.
And so he didn't get his, he didn't set, so he had, Mr. Willoughby, you had to take classes again?
No classes, no.
No,
Just
we
No
walk-
just had to
classes,
take
Just walk-
just retest or
Just
just
walk-
get his license
Just
back?
walk.
Retest.
So you had to retest.
It was, yes, I did.
Okay.
That was a mandate by this board.
So you retested.
Not for classes.
But you didn't get your license for another year and 5 months after that. After we said that you could get your affiliate license,
If that
a year and 5 months later you got it.
If what Ms. Maxwell read is correct, yes.
So that's,
If
I guess, our sticking point is you've only been an affiliate broker for 1 year. So you have to be an affiliate broker for 3 years.
I understand.
To become a broker.
I do understand.
So are you asking us to waive that requirement and get your broker's license now?
Ma'am, but I was not allowed to finish my statement.
No, listen, I want you to tell me what you're here for. What is your request?
My request, now I'm going to start over.
I want you to tell me what is your request.
I'm going to repeat respectfully that my request.
Okay, so this is not going to happen. This is not going to happen. Please, sir, I'm asking you, what is your request?
Statement.
Reinstatement as a broker. Okay, thank you. Now you can tell me what you want to tell me.
Yes, ma'am. Okay. Couple things. I was mentioning that I signed a document admitting to monies, that sort of thing. This statement, item 28, respondent action and conduct described in the following allegation and facts constitute a violation of code blank, blank, blank. That code blank, blank, blank did not mention these items there was a variety of things read in that code. None was specifically mentioned in this order. I did not specifically sign anything admitting to any allegations of money.
We're not going over that again, though.
But I just want to clarify.
We're only here to address you getting a waiver that you consider as a broker. We don't want to go over all that happened in the past. That's in the past, and
she just read it.
Okay, it doesn't matter to us, though.
It's incorrect.
No, it is not incorrect.
I mean, incorrect that I signed a document stating that specific item of the code.
Okay, that's not correct.
That is not correct. But there are many items in that code that could have been correct.
Sir, I cannot let you stand here and say things that are not true. I'm sorry. She has the affidavit that was signed. We all have the affidavit that you signed. So all we're here about is I need to know why that this commission should waive the requirement that you have an affiliate license for 3 years when you're asking us to waive that. What are the circumstances?
Ma'am, I am not asking you to waive that. I believe that the policy that is in place is in order. It's a policy that has been made and been in place for many years. I have no.
Where did you find that policy?
Stated that.
Okay, it's a law. It's not a policy.
Law. It's
statute.
Statute. I have no objection to that statute. My only purpose here today is to clarify items that are misread as my intention of signing a document.
We're not going over that again.
But that's not going to happen.
No, sir.
I'm not going to be allowed to clarify
no,
the record.
Sir. That's finished. That's all finished. We're here today for you requesting an exemption, and we just need to know what is your reasoning that we waive that requirement. That's all we want to hear about today, because what's passed is passed, and there's no need in rehashing that.
I'm giving you the information that you won't allow me to give you.
No, we already have all of that information.
Well, evidently this board has not heard it, and
we're not going to rehear it.
It will be the voting members that were not allowed to hear it.
No, they have all gotten copies of the order that was signed.
But order does not give you the circumstances that they would need to know about.
Okay, I'm going to ask you one more time. I need to know, what is your reason for us to waive this? This is all we're going to talk about today. I'm sorry.
I'm asking this, allow me to state my position, which you will not allow me. And
no, so we're not rehashing
and if that
what's
is
done.
I'm convinced that this board would agree with my words. But I'm not going to be allowed. That's going to be on the record, please. That I'm not going to be allowed to state my case.
Sir, it seems like the opportunity for you to state your case was in 2018.
But I did, sir. Yes, I did, and
that board at that time
my only
offered this consent decree. That
yes, sir. My only thoughts to that are there are people here that would have to vote that are not privileged to.
They have the documents. They have your documents.
So it seems like you're asking us to add facts to the record that the previous commission heard and decided. and
At facts, I'm sorry.
that the previous commission in 2018 heard and decided, or that at least you agreed to in this consent order. So if it's incomplete, I mean, it's kind of not this board's fault or Trick's fault that the facts in the consent order aren't complete. Your attorney had a chance to read it, and he signed it, and then you signed it.
Yes, sir.
And then the assistant general counsel at the time signed it, and it was entered into the court record. It cannot be unlocked. It cannot be undone. And you've complied with the consent order already.
Yes, sir. I would not. I'm not asking that to be redone. I'm only asking to clarify the records. I did not sign a document that I willfully or illfully misappropriated funds as stated by legal counsel.
We have copies of it.
That language is not in here.
We have copies of it.
I have it here. It only mentions the code number, not the actual act in that code.
Okay, I need to ask my attorney. Excuse me, Mr. Willoughby.
I'm sorry. Go ahead.
I need to ask my attorney. What do we do at this point? What are our options?
Mr. Willoughby,
okay.
I need you to listen to me carefully. Precisely state what you want the additional board members to hear, what you believe they need to hear. Concisely state what it is.
I would want the additional board members here to be able to hear the facts.
Concisely state those matters right now. State them.
Well, do I have time?
Yes, concisely.
Or let me.
You have about 2 minutes.
Oh, that's impossible. That's impossible. If I will be allowed to state my case, I can come back to a different meeting.
Begin stating your facts right now, please.
Okay, to address the board on the members that were not privileged to be a part of my initial investigation, the stipulated facts is a generalization of the items that took place. Item 8 in the stipulated facts state there are no findings that respondent personally misappropriated or used any escrow funds, etc. Also state the respondent, when he found out about any deposits in his leasing office, ran a press release, fired everybody. And by the way, they opened a new company, and most of the allegations were done by a different company, which was my son, Willoughby Leasing, Adam Willoughby. I have that document here. And I fired everybody and then asked them to change their name because I'm getting complaints at my office for things happening at a different office. But when Mr. Willoughby, Anthony Willoughby, got wind of any issues, we sought after those people, ran a press release, and made sure they're all paid and fired everybody in the office that was associated with the leasing agency. Secondly, in dealing with that, we were somehow misconstrued to think that my office, the leasing agency, was the management company. We collected money, we held the money. No, we were those guys just did paperwork only, and that never came out. Paperwork only for the management companies. Once those packages were finished, and he did everything that a mortgage company would do, collect the verification of their rent, collect their credit report, collect all the items involved, check stubs, et cetera, et cetera, et cetera. The package was done with that person deposit and sent over to the management company. My office did not hold it. And once that package left my office, that office was done. We had no other thing. If they leased to that person, they would send a commission. If they did not, they would not. We're done. Any rents collected, any problems with the property, I saw some things in the complaint where there were repairs issued. I was complaining. We had nothing to do with those properties. That office only handled paperwork for the management companies, period. Again, as just stated, when I found out about it, I did everything a broker could do. Say, who lost money in my office? Had my attorney run a press release. If anybody lost money, come to me, I'll pay you. I exited everyone that was in there, in that office, out of there, and shut it down. And they opened a new office, and it continued for 6 or 8 months. I was getting complaints about Willoughby. I'm not the Willoughby. I have that documentation here and the corporate charter on that. Okay. There are the statute that council read made mention that funds that were taken into an office were not returned properly and in a timely manner. And I do understand that. And as I mentioned before, in my initial meeting, Jeff, you weren't here in 18, I believe. Were you here in 18? I brought the checkbook. I brought all the information. I showed money's coming in. I passed it around. I said the monies came in with the package. The monies went out to the management companies. We didn't have it. I brought all that information. It was seemingly ignored. And that's why the statement is Mr. Willoughby did not misappropriate any funds. But if it was, I have children. You have children, most of you. If your child breaks a window, you're responsible. So I'm not shucking any responsibility, even though I wasn't there and knew about it when it happened. I'm responsible for that. And that's why I stepped in, fired people, ran press releases. I stood responsible for that. I believe in responsibility. I'm not shucking my responsibility. I'm only saying that I personally did not know about these things. When I got wind of them, took care of them, but it was late, evidently. I understand that. That's a rule. I stand responsible for that as well. Whether I know about it or not, I stand responsible for it now. But let's just look at that for 1 second here. I want to allow you to see how things are handled by this board, this commission board, in other situations like that. And I have probably 20, 30, 40 of them, but I'll give you just a few, okay? Because I know this sort of thing does happen. Why is it handled differently from one to another? I don't know. But bear in mind, there is a statement. This is a court
Better have
order.
some proof about that, sir.
This is yes, ma'am. I have it here. And you have it as well. It came from your commission meeting, this commission meetings here. Everything I'm about to read now came from the commission meetings here. Okay. Everything. There's item 8 in this court order said that I did not personally misappropriate, but I am responsible because my office did. I'm going to clarify that. I stand responsible. But
is that what it says, Anna? Is that what it says? Okay. Go ahead.
Okay, that's what it says. Anthony Willoughby, respondent, did not misappropriate any funds. But I am responsible because my office did. Before I fired them and they opened, those guys took off, opened the office. But there are a few categories here. For example, I'm going to give you a few of them if you'll listen to this. Okay. We have John Mark Holloman in Clarksville, Tennessee broker. This was in December of 2016. It'll be in your records. And I have all the information on these, just briefly. Failed to remit money in a timely manner, was given a $1,000 civil penalty, went back to work. Venture Resorts Incorporated, Cabins in Pigeon Forge. This Tennessee company substantially willfully misrepresentation of funds, failing to the count, failing to remit monies to it came into the licensee possession that belonged to others, and earned commissions due to owners, not dispersed monthly. They held money, did not disperse money, on down the line, $1,500 fine. Went back to work. Okay, another one. Summer O'Neill in Lafayette County, Tennessee. Agent failing to interplead earnest money funds within a certain amount of calendar days, as they should have done. $500 fine. Go back to work. I'm not done.
We'll hear.
Christopher Cottrell, please, if I may finish with you.
Excuse me. Every commissioner up here is well aware that we have misappropriation of funds, interpleaders, all that thing problems, and yes, we have those things come up all the time. The commission that heard your case, though, took all the facts from your case to make the decision. There were multiple cases of misappropriations, and the money had not been paid back to those people. And so that's why we entered the order that we did. So you don't need to keep on going on and listing these. You're right. We do have these kinds of things, but we have to take them each on an individual basis and consider each one on an individual basis. Excuse me, Mr. Tolbert.
So you have obtained your affiliate broker's license, correct?
Yes.
So you've been able to go back to work.
Off of this now?
Yes, we're off.
I'm just asking because each time you've said they've paid a fine and they were able to go back to work, you also have been able to go back to work. So I don't understand.
Let me clarify
your
that.
point.
They did
there.
not lose their license. They did not lose their status as broker to run their company. You follow me? That's what I meant by that.
Yeah, and he
Also-
wasn't present for any of that.
But my
Also,
court
I'd
order.
just like to clarify. I mean, I understand the point that you're trying to make, but this commission can't speak to that because all of our
We've been heard.
complaints are handled anonymously. So they don't know the complainants that you're talking about, the respondents you're talking about. They did not know who you were at the time because you were presented anonymously. So you can give them names. They don't know the names. They know numbers. And they know the different facts and they know facts. They don't know specifics. So the particulars you're talking about, again, everything is specific facts and circumstances based on a different individual. So
And I would like to say
this
as chairman of this commission. We are only here to hear his new information about why he should receive a broker's license when he's only been an affiliate for 1 year. We all have the information that you're speaking from. I think we've heard enough. And Mr. Willoughby, if you'll be seated, please, we'll have a discussion about it. Thank you for coming. Okay. So I think it's pretty clear that the law says you have to be an affiliate for 3 years. Mr. Willoughby has presented no information to us of why he should have an exception to that rule. I don't even think the law grants us that opportunity to do that. So I'd like to hear some conversation for the commission. You all have the records that he's of his problem that he had. I'm just trying to let's move this thing on. We don't need to relitigate.
I just think it's important to acknowledge that this is not new information. This is information that we've had since 2018. So nothing has changed since 2018, as far as I can see, other than his argument that he didn't mean to sign it, basically.
The only thing that we're here for today is to decide, do we let him skip 2 years and sit for his broker exam?
I'm a little confused. I'm wondering why Mr. Willoughby is he? Can I ask him a question? Are you saying that this signed document that we have in front of us that's been here since 2018 is incorrect, even though you signed it?
Sir, that's not what I mean. And it does state that Mr. Willoughby did make sure everyone was refunded, and that's long before I came to the 2018 meeting. All those people were paid.
He had to satisfy that before he could come before us for another informal hearing.
So whatever this says, which we can read for ourselves, is correct. Is that what you're? I mean, you have no debate about that. So I do. Yes, sir. Okay, so you don't.
But we're not relitigating. We're not relitigating it.
This court order, if you look at it, state that before I ever came here, all people involved under my watch were all refunded long before I got here. That's
Before
in that
he
order.
came before us, they had not been refunded. When he came before us, they had not been refunded.
Someone read that court order, please.
No, sir, but you can sit down again.
It's here.
Okay, so I don't want any more
I'm not
questions
gonna be
asked of
allowed
Mr.
to
Wilson,
show proof.
please. I mean, you see what the
I'm not going to be allowed to show
problem that I
proof
have.
of this allegation. It's right here in the court
So,
order.
does anybody have any reason that we should even take a vote on this today? We don't have to take a vote, or we can take a vote. But I think it's pretty clear an informal appearance is to ask for a favor or a waiver. And I don't see that we can even vote on that because it's against statute. We're not the one that makes the law.
If we're allowed to vote on it, I'm okay to vote on it. I want Mr. Willoughby to understand that you seem to think that we don't understand this. And we do understand this. And there's no new information. There's what you have to say about this document, but there's not any new information. Everything in this document is accurate. And you've pointed out number 8 says whatever it says, we can see that. So what it says is correct. Number 8 is correct. Okay, it's in the document. So I just want you to understand that we understand. And if you had people under your authority that you didn't agree with what they were doing and you fixed it, that's great. But that does not change what we have in this document that you have signed and agreed to. So I don't
Have legal counsel read number 7.
I don't know
And I'm done.
what new information
It's not
you
new.
have brought us.
It's not new, but if you could have legal
So it's
counsel
not
read.
new information. So you're asking for us to waive the requirement of 3 years to get your broker's license.
No, ma'am. I didn't say that.
So that's not what you want.
No,
That's what he
ma'am.
stated in the first because I wrote it down.
Because that's what you said
He wants
that you wanted.
reinstatement.
You want to
Of
get
his
your
broker's
want to get your broker's license.
I want to be reinstated, as the court order says. I didn't ask. I will abide by whatever this board says, but that's not what I asked.
Okay, so,
And if counsel
I
could
would
read
like to know.
paragraph 7, please.
No, sir.
Because it says all monies were refunded before I got here. All. I owe
that
no
was
money.
refunded.
Okay.
That
We
was
did- I did not-
that is clear. It was refunded.
Yes.
It was refunded.
All this money was refunded. All right, so
I would like
we're
to
going to
say-
move on from
Hold
this.
on, I want to ask counsel a question.
Okay.
So I like how he goes to paragraph 8. I'm going to go to paragraph 29 where he says the respondent shall voluntarily surrender his license. So now when he did that, that license is done, dead. It can't be brought back. Okay, so when he got his affiliate license in that meeting 2 years ago, that was a brand new license.
And we granted him grace to even be able to sit for an affiliate license.
New number, everything. He's like a brand new baby broker.
Yes.
Correct.
Yes. All right, so does anybody have a motion?
Wait, Joe's got.
I'd just like
Joe.
to say something about. I felt like the integrity of the board. I just need to say that on the where you were reading those things that we had responded in different ways to different cases. We don't know. We have numbers. We don't have any prejudice from one thing to the other. We don't know who is in this case. We didn't know you when it came, and we didn't know any of those people till you read those names, or they're published in something eventually. But we don't have a chance to play a favorite to somebody. If we know anybody, we recuse ourselves. And I just wanted to say to the people in the audience and stuff, that didn't look like, it may look like we did different things to different people or cases, but those are just all in the moment, hearing a case, making decisions, and we don't know who it's about. So I just wanted to say
And according
that.
to those specific facts.
And I know that this has been mentioned before. If you didn't agree to the information in here, you shouldn't have signed it, but you signed it. Your signature's on it. So
His attorney signed it for him.
that's the end.
All right.
No, he signed it. He signed it.
I signed the document.
Your name is
Go right
on
at
this document. Your name is on the document, and
We all have copies of that exact document.
My name's in the document. Yes.
No,
Yes.
your
your
signature is
signature.
on the document, and your signature's on the document, sir. And I'm really I'm done with you mischaracterizing this document. It's signed and it's done and it's entered entered order with the court.
Forgive
We're
me.
not
That was
talking. We are not talking about this agreed order, Mr. Willoughby. Have a seat.
Is that
My
ship
apologies.
has sailed?
Have
It's
you
over.
signed
It's
it?
over.
You've
You're an
agreed
affiliate
to it.
broker, and you know, it's like Mr. Grease told you when we granted you that he had to make you stop talking and tell you we're fixing to vote to allow you to have a license, but you got to stop talking. Okay, so we agreed to let you be an affiliate broker. Now we have no say in what the statute says. So unless someone has a motion, then we're going to stop this and we're going to move on.
Do we have the authority?
No. That is my legal opinion is no. You do not have the authority.
It's the question
and
I
that's
asked
what
in the
I
very
said.
beginning.
The answer is no.
I just want to make sure
Yeah.
we have no authority here, so there's no need to make a motion.
Okay, moving on to the next item on the agenda.
Miss Countess Brown and her
Is on the
principal
line?
broker are now on the line.
Great. All right, Miss Brown, let us switch over to your documents real quick. And what we're going to do is we'd like, Caitlin, if you will read into the.
Miss Brown is now. Is now a good time?
Yes, now it's fine.
Okay. Thank you.
You're welcome.
Okay, before you have applicant Countess Brown and her principal broker, Matt Lange. Ms. Broker has taken the Tennessee Real Estate Affiliate Broker exam. The firm is Matt Lange Home Experts Advisors, LLC. A summary of criminal and disciplinary sanction is shoplifting, and Ms. Brown's statement and a letter of recommendation can be found in your packet.
Hey, Miss Brown, thank you for being here. If you would tell us about what brought you here today, what happened with these charges, what's happened since then, what you've been doing, and tell us about what has what is your interest in getting a real estate license? Can we bring her picture up?
Miss Brown, are you able to turn your camera back on?
Yeah.
Okay, thank you.
And is your principal broker there with you?
He's on the line as
He's
well
on the
and
line.
is separate.
Okay.
When the charge first happened, I initially wasn't the person who did it. I was actually with someone who I thought was a friend. And they thought, since we walked inside of the store together and we separated, they initially said that it was pre-planned and it was something that we had planned already before coming inside the store. Once I was charged, I did have to do community service. I completed that. I also did probation. I completed that with no problems. After that, I went on to I worked with special needs. I worked there, I want to say, for 2 or 3 years. After that, the whole time I was basically in healthcare. I'm currently in healthcare. I'm contracted now with West Tennessee Healthcare. I haven't had any issues. I've explained what happened, even though it was not showing up on my background because I had tried to get it expunged because I knew the issues that I would have with it. I don't know exactly what happened with the expungement after I applied for it. I never heard anything back from it. But like I said, I haven't had any other issues with it. I've explained to every job what happened. So like I said, for my real estate, I feel like real estate is where my heart is. I've worked exceptionally hard with the issues that I've had that has arrived, such as my birth mom passing, just a whole lot of issues. I never stopped trying to get my license. I pursued it. I tried really hard and I worked hard because I knew it was something that I was really passionate about doing. And I'm going to continue to just be the best person that I can be because I'm not that person. I've never been that person. I look at myself as a very upstanding person. I've always tried to do things to better myself, for myself and my kids, because I have 2 kids also.
Okay, thank you. Do any of the commissioners have any questions of Ms. Brown? Okay, so we're going to move on to your principal broker. And let's see, who is the principal broker? Oh, Mr. Lang. Mr. Lang?
Yes, can you hear me?
Okay. And Mr. Lang, we're going to want to hear from you about how you know this applicant and what your plans are for her in the future, a little about your training, that kind of thing, please.
I've known her about a year.
I can't hear you.
We're having a little bit of trouble hearing you. It sounds like potentially the microphone might be blocked or.
Is that better?
That is better.
Okay, I've known Ms. Brown for about a year and a half, as she would come in the office and working
Wait,
on,
one second. I can't hear that. It's mumbled. Can y'all understand what he's saying? Okay.
We're still having a bit of trouble hearing you. Maybe you could just talk a little bit slower and a little bit louder.
Microphone.
Oh, use that one. Give me 1 second, I'll get a microphone. Is that better?
I think that can we try again, see if that's okay?
Yeah, is that any better?
Yes, much better, much better.
Okay. Yeah, I plugged the microphone in. Yeah, I've known Ms. Brown for about a year and a half, as she would come in the office and working on her license to pass the test. Every time she's came in, she's been, very nice, very pleasant, and always looking, try to get better in her life. For our training, we do weekly trainings. We do in-house training. We've got, a teachable course, plus we have weekly trainings in-house, For her, as a new agent, we know the difficulties that we move into as, the new market is everything else. And, kind of how can we best serve our clients and be, advocates, whether that's on the buy or sell side.
Okay, how many agents do you have in your company?
Five.
5 people. Okay. So when she goes out for her first listing or writes her first contract, what will you do? How will you help her in that way?
Well, during the owning board, portion, we go over all that, to start with. And then we also have an in-house transaction coordinator to help review with it. And then we go over it with it as they write their first initial couple contracts,
Okay.
to make sure that they're correct.
So you're sure that she's comfortable before you let her go out on a listing presentation, that she knows how to fill out all the paperwork and all of that?
Yes.
Okay. Any questions from any of the commissioners? Is there a motion for this applicant?
Move to approve this applicant.
Second.
Okay, we have a motion to approve this candidate. Let's see, by Mr. Ferris, and a second by Ms. Tolbert. Any other discussion? All those in favor of the motion, say aye.
Aye.
All those opposed? That motion passes unanimously. Ms. Brown, good luck to you, and make your broker proud.
Thank you.
You're welcome.
All right. Thank y'all.
Thank you. All right, so, and we still don't have Kelly Turner, right?
Miss Turner will not be.
Oh, yeah, you told me that. Okay. All right, so next is the executive director's report.
Hey, I just have a couple quick updates for the commission and then open to any questions. Primarily, I wanted to reiterate that it is E&O renewal season. So hopefully you got a couple reminders so far already about renewing your E&O. We started sending out reminders in October, and a majority of our licensees will expire January 1st of 2023. And so we want to avoid anybody possibly getting suspended. So just wanted to do a quick plug that it is renewal season, and suspensions will be taking place in January for anybody that expires on January 1st of 2023. And then the other update I wanted to provide everybody is I've previously mentioned a distressed county project that the Real Estate Commission is working on, and that is to offer pre-licensing courses to high school seniors in the distressed counties as another avenue to an occupation, potentially other than going to college. And the newest update is that we are working to get that approved as an elective in the high school where they would be able to take it during the school day. And so I'm currently working with the Department of Education to try to make that happen. And that is just for the distressed counties at this point, based on the governor's priority to provide economic relief in those counties. So I will continue to keep everybody updated. Right now, if a student wanted to go tomorrow and take the courses, they could, but we are working to do it through the school system to hopefully better set them up for success so that it's in the school day, and that they have 90 hours is actually perfect for one semester, and so that they can do it through the school day and not after school on the weekends, that sort of thing that a high schooler might not be able to fulfill.
So is this something that the schools would have their own instructors within their staff that would teach the classes?
So it is an asynchronous courses that were approved and that we have the contract for through Kaplan. And Kaplan is on board with the project, excited about the project, and they are providing instructors that can answer questions specifically about the course. My understanding with the meetings I've had with education is that they would be required to have a teacher in the classroom, but Kaplan will be providing support in regards to questions that might come up as you're studying and taking your pre-licensing courses.
So it's actually Kaplan then that has the instructor certification.
Yes, they have the instructor certification, and they've done something similar to this in Texas. And so this isn't necessarily their first time offering something of this nature. And they do have those resources and they're provided in the contract. But to answer your question, for it to be approved as an elective, there does have to be a teacher that's in the class with the students.
I think that's great. How are they going to market that?
Well, so this is kind of evolved. Obviously, this is a first-time project, and you don't know what you don't know. And so I have been working probably for 2 years to get the contract approved. And I met with one county in the summer, Clay County, and they had suggested that we should get it approved as an elective, which made a lot of sense. It's been a while since I've been in high school, but I think imagining a high school student wanting to do this over the weekend or after school might not be setting them up for success.
Yeah.
And so the directors of schools in Clay County had suggested getting it approved as an elective. And so that's the process I'm going through right now. Unfortunately, it's not as quick as I would like. And so what I have recently discussed with the Department of Education is doing a pilot program in one of the counties as a way to get it approved a little bit quicker. And then the next school year, being able to have it approved in all of the distressed counties to where all those students could take the course.
Fantastic.
So,
did I see a hand?
So I have two questions. So what constitutes a distressed county has been defined? And
Yes, and those are constantly changing. I'm not sure of all the criteria that constitute it, but there are factors because when we started this process, there was, I think, roughly like 14, and now I think there's like 8 or 9. And so I do know that they're constantly changing and evolving based on a set of criteria that I'm sure has been outlined by the governor's office.
And then something that I've experienced with my son and his electives at school is that every now and then the school administration will change the schedule for the school day and will cancel out the electives and do something else.
Yes.
Hopefully with some instructional value, but nonetheless, that elective doesn't meet for that day. So I just want to make sure that the 90 hours that we're talking about is something that can absorb that kind of flexibility or that kind of change in a school day for the school administrators.
Yes, yeah. I think I will ultimately defer to education on that, just because there's other trade programs that offer something similar. Will be the first time that they've really gone into like what they're classifying as the business realm. And so I'm sure they allot allowances for changes to the schedule, snow days, that sort of thing. And there's no criteria that they can't finish it after the semester. But we do still have the laws that they have to take the test. And once they take the test, they have to submit to us within 6 months. So all of those laws will still all be followed.
So theoretically, a 17-year-old could take it and turn 18 and sit for the test.
Yes.
Okay.
We are mainly marketing it just to seniors because of the 18 age requirement. I have already talked to PSI about this program, and obviously this is something we're going to want to monitor closely and track. And so I'm going to get a specific test code set up for this group. And I have discussed with PSI being able to take it before you turn 18. They just can't apply to us until they're 18.
Okay, so if they take the course and test, their test passage is valid for 2 years?
No, their test is only valid for 6 months. So they will need to take the test and then apply.
But passing the course is valid for a period of time.
Passing the course is valid. Once you pass the course and you're approved, that's valid. Yeah.
And I think this is one of Governor Lee's big things. I mean, he's always talking about things like this and helping our students. And I think this is a great initiative, and I applaud you and him both.
Don't applaud us until it's done,
well,
but yeah.
We're expecting great things.
Question.
Yes.
So, Caitlin, is it essentially the teacher in the classroom hitting a button and letting Kaplan give the course over like a video screen or something like that? Is that
so
how
essentially
it works?
they just need a computer.
On their computers.
They just need a computer because it is an asynchronous course,
right.
And so it can be taken anytime. We're wanting to do it through the school system just to have that allotted amount of time that they can dedicate to it.
In the school building.
In the school building.
With their computer.
With the computer. In a structured environment.
So the student is relying on getting other information or whatever from a person that's not in the classroom, more than likely. I mean,
yeah, there are resources that Kaplan does provide, like exam preparation and those sort of things. So that way, before you take the test, you can re-go over everything that you've learned in the course of the semester. But
it would be a good volunteer option, possibly, for a licensed agent to be in the room. I mean, I'm not saying they're teaching it, but
yes,
if I was a student, I had questions, and I've got to go to somebody that's not there. It would be easier to feel like I'm learning, I would think, if I had somebody I could talk
resource.
to. Correct.
Yes, I have thought through some of those things, whether there could be some kind of like mentorship program aligned with this, with an agent that is in the profession and could be a resource. That's something I thought of. I'm just trying to take it one step, but I do think that is something that I thought about that I think would be a good idea.
Anything else for your director's report?
Nothing unless there's any questions.
Anyone? Okay, so.
Well, actually,
Yes.
Ms. Maxwell, did we decide on a meeting schedule for 23 last night?
Yes.
Okay.
And I can resend that out. It is posted on the website now. It is officially.
So we had conflicts every year on the October meeting. It's always during fall break, and it's always during big companies conferences. So you'll be glad to know, Joe, that you'll be able to attend in East Tennessee next year.
It won't be over fall break, at least.
Yes. Okay, so now we're going to move on to our legal consent agenda. I don't have a list of what's been pulled.
Would you like me to read it out?
Yes, please.
Okay. And I'll note.
Hold it.
Yes. Number 1 was pulled by Franks. Number 6, Franks. Number 7, Smith. Number 9, Franks. Number 15, Smith. Number 16, Franks. Number 17, Franks. Number 22, Franks. Number 35, Franks.
Except I'm took off number 22.
Okay, so you're okay.
Yes. Okay. So does anyone else have anything else that needs to be pulled from the consent agenda? Okay. So let's have a vote on that then. All those in favor, say aye.
Aye.
All those opposed? That motion carries. Wait a minute. Nobody made the motion. Excuse me. I need a motion for that, actually.
So I move that we accept council's recommendation.
Okay.
Second.
All right, I have a motion by Mr. Diaz and a second by Mr. Moffitt. All those in favor say aye. Aye. All those opposed? That motion carries unanimously. Okay, one thing I did want to say, just as we were saying earlier about how we don't know who any of these people are. We get numbers. We get complainant and respondent. And we get the legal documents sent to us a week before we have these meetings. And so we read through all of these. Our attorneys make recommendations on what they think the findings should be, whether to dismiss or to give penalties. We sometimes agree with them, sometimes we don't. Sometimes we have questions about it and not sure how to do it. So we have shortened the agenda by having a consent agenda, meaning that we agree with what our attorneys' findings were on those things. And the ones that we disagree or have questions about, we pull from the agenda. So that's why we only have a few out of I think there were 37 this month. But I did want to say, and I know that our previous attorney is not in this department anymore, but there were several cases that we've had that had either she or East Tennessee or West Tennessee. Normally, we don't get any information on anybody, not she, not he. It wasn't Anna that did it, though. Not she, not he, not where you're from. No information. So, and then I'm every time the newsletter comes out, it's a quarterly newsletter. I'm as anxious as anybody to look on there and see who are the people that we penalized. So we actually have no idea. If somebody has called me and says, I have this problem, I'll say, I can't talk to you about it unless you want me to recuse myself from it. So it is totally anonymous to us as to who these people are.
Completely anonymous.
Completely. And even down to the she and East Tennessee and West Tennessee. So there's no prejudice involved in these decisions. And that's really the best way that we can do it. I just wanted to make that. Okay, so on number 1, and I know this was, yeah, we already voted.
We did.
On number 1, and this was Mr. Gregory's case, and he's not here with us today.
I'm going to do my best.
Okay, my question on this one is, this one was about percolating. Okay, so is the test for 3 bedrooms or 4 bedrooms, 2 bedrooms? And my question is, the answer to this, and Mr. Gregory's recommendation is to close, but before I can say, okay, I need to know, he said that the plat shows the number of bedrooms on the plat. Do we have a copy of that plat?
See,
And does it indeed show the number of bedrooms?
While council looks that up, it was mentioned that we were on YouTube earlier with these meetings, and I'd like to point out, this is not true what I'm saying. This is not true what I'm saying, but Joe Begley is getting a ton of money from name and likeness imaging and royalties from YouTube, and I've only gotten a dime.
And that's not true. That's why he bought dinner last night.
there is a plat.
Okay, and does the plat show the number of bedrooms on it?
For making an assumption, I know. Jeff does.
I could do the plat. Let's see. Where's the?
One.
No, they do not.
Okay, but what is this right here?
Hold on one moment. The plat map does not indicate how many bedrooms the lots are perked for.
And is there over to the right, is there a column that shows lot 1, 3 bedrooms or anything like that? Yeah.
Oh, here.
Lot, so
yes,
lot,
so let's look at
lot number 1.
No, we're going to 51.
Yep.
It says it's not to exceed a certain number of bedrooms.
Okay.
It says
what's that number?
With proper structure, driveway, and utility locations outside of usable, not to exceed 3 bedrooms.
Mm-hmm. Okay.
So no, that's for this specific lot.
So, yeah, we don't know their lot number. Well, the problem is this: it's not.
And for this,
it did not close. We know that.
And then for
but
this,
if the complaint is that someone's misrepresenting and advertising that.
For the second 4 bedroom.
Okay. Good to know. All right, my motion is to accept council's recommendation to close.
Second.
Oh, wait a minute. I can't. What, did you make that note?
I'll make it.
Okay.
Yeah, I'll say.
All right, we have a first by Ms. Tolbert and a second by Mr. Diaz. All those in favor?
Aye.
All those opposed? That motion carries unanimously. All right, number 6. Number 6. Okay, so number 6, the principal, let's see, this is property management. And I think they say they are unlicensed. I believe she is being filled. Okay, this one had a regional property director that responded to the complaint and says that they do not have to have, they don't have to have a license. It says it's unlicensed, and there is a licensed principal broker who oversees the day-to-day activities So that one threw me off. The violation, it says the complainant believes she is being retaliated against by the landlord in violation of 6628-514. I could not find that in my green book. What is that? Is that not correct? 6628?
That doesn't fall into our purview.
Okay. All right. No wonder it's not in my book. Okay.
That would be under
close
the,
it?
I'm pretty sure that's under the Tennessee TRLTA, the Uniform Residential Landlord Tenant Act.
Okay. Okay. Then I'm okay to close. Yeah.
Motion to accept council's recommendation.
Second.
Okay. We have a motion by Mr. Diaz and a second by Ms. Tolbert that we close that. All those in favor?
Aye.
All those opposed? Motion carries unanimously. Ms. Smith is number 7.
Mr. Willoughby got her fired up.
Thanks again. I'm sorry. You say something.
No, ma'am.
One that said, one that did not. It is property bedrooms. But,
Oh, Commissioner Smith, can you turn on your mic? Sorry. I just realized.
it appears that the complaint is saying that someone is advertising property for so many bedrooms that may not be correct. And the respondent said that they did not have a good method in which to respond to the complaint other than using their current listings. So it sounds like what the respondent is saying is, I list the property and I list it for ever how many bedrooms, but if it has a septic tank, I don't go check to see how many bedrooms it should have had or is serviced by. So, most of the time when people list property in rural areas, they get some information from the county showing how many bedrooms were approved for that property. So I guess I'm concerned because the respondent just said, I don't have a good method in which to respond other than just sending you some copies of some listings I had.
Well, it also says that the respondent has not listed any new homes, which is what the complainant seems to be complaining about. That's her
assumption, but it doesn't say that it's a new home. It sounds like it's just a complaint regardless of what how old the house is or the property is. Read it again.
Well, it says she's unaware of any restrictions on the number of the bedrooms for the house. And you're right. If you've got a house that you're going to list that's got a septic tank, you better go get that septic letter. And I think that's standard practice that anybody would do that. Anybody have any other thoughts on it, or you want to make a motion?
So,
Jeff. I think we need a bit more care in this situation. Letter of instruction. Just reminding us.
This person has been licensed since 2008.
That if you're going to advertise a property that has septic tank and you don't know if you've got the right number of bedrooms for that property, I think you're going to get in trouble.
So you want a letter of instruction?
I do. So that's my motion.
Okay. All right. We have a motion by Ms. Smith and a second by John. John, I've lost your last name. Moffitt. I have it written right here. I have it written right here. That we send a letter of instruction to this realtor.
So one final bit, the letter of instruction is going to be about exercising reasonable skill and care?
Reasonable skill and care.
Okay, so we are not finding the respondent liable under the Tennessee Consumer Protection Act for anything.
It's just a letter.
We don't do that.
Yeah, we don't do that, but the attorney responded based on that. So yeah, I just wanted to record we are finding this letter of instruction based on our statutory authority.
Right, I can clarify that for you.
Okay.
Okay. All right. Yes. I'll include that's not in our jurisdiction.
Perfect. Thank you.
Okay, all those in favor say aye.
Aye. Aye.
All those opposed, no. Okay, we have 8 yeses and 1 no. Mr. Ferris was the no. Okay, the next one is number 9. Okay, this is another one. The listing agent did not know there were 2 there. She thought it was a 4-bedroom house, and
Permit was for 2.
and this person, they're their listing agent. Okay, so they listed this house as 4 bedrooms, but it was only 2 bedrooms.
Or
Well, I guess one of my questions was, it goes to skill and care again for the same reason. And did she not go in the house when she listed it? I mean, usually you go in the house and you see how many bedrooms there are.
I pulled this
2.
one also for the same reason.
Okay. So, so you want to make another motion, or anybody got any discussion about it?
I have a question.
Okay.
Public member.
Yes, Ms. Public member.
What is the law if it's not new construction? Because the one before said the law is about new construction. So what is the responsibility of an agent if it is not new construction? Like, what's the statute say?
Right, where does it say that it's new?
In the one before, so in the...
No, I mean on this one. It doesn't tell us it was new construction.
No, that's my question, is so the
Well-
law that it references in 7 was about new construction. So the Tennessee Consumer Protection Act creates a cause of action for buyers where a new home is advertised. Is there anything for an older home, like is there a violation, or it's just you should know?
Even if there was, I don't think we have the authority to do anything about it.
Right. So Tennessee Consumer Protection Act is not something that we have like jurisdiction over. So when there's something that is like related to, I don't know, consumer protection is like our general, like what we do as consumer protection is to make sure that taking care of consumers and what they're so when you think of consumer protection, you're thinking of looking for their rights, or making sure that they're sure that they're not, or those types of circumstances.
So my question is there any kind of violation for a licensed real estate agent if they don't disclose the accurate perk for how many bedrooms, if it's an older house? I mean, they should. I agree that they should.
Only if you could prove they knew beforehand.
Right. So I think the argument here for this one is talking about adverse facts. And when I think of adverse facts, I think of something that's like a very, very high standard of something that would, so like if you look at the definition of adverse facts, it's defined in our statute. It states, means conditions or occurrences generally recognized by competent licensees that have negative impact on the value of the real estate, significantly reduce the structural integrity of improvements to real property, or present a significant health risk to occupants of the property.
So obviously, you know,
I don't know if I necessarily think that 2 less bedrooms.
Question.
Oh, hold on. So for me to be clear.
The difference in the new home construction is when you're building new home construction, a contractor gets an exemption from
Right,
any
no,
disclosure.
I understand all that. I'm just saying as an agent.
But even
what's
at
your
that,
obligation?
I would want to go for skill and care to get a septic letter, and he's going to have one to even get a permit or a CO for it.
But just for like general, just so you can generally understand, consumer protection matters. Those statutes, even though they don't fall into our jurisdiction, they usually deal with newer materials. So we're talking about like lemon laws for like a brand new car. So if you have a car and it's brand new and something goes terribly wrong within like the first 30 days of your car, you can get a brand new car. But after like day 31, it's not really, it's not something that you can recover from. So once something is not considered brand new, then that's not really something that would fall outside of, that would be considered newer, like the statutes really apply to. So when something is older, statutes still apply, but it's going to be harder to prove that there's something that is just, I guess there's a latent defect because it has existed longer. If that makes sense.
That's kind of my question is
there a statute on point that talks
well,
about...
not even a
like,
statute, but I guess it's your responsibility as an agent, but it's not a violation if you don't know, if it's an older house.
Like, there's nothing specifically that talks about rooms or anything. So what I think...
as practitioners...
Right, understand the words they said. Their reasonable skill and care is the category that they're putting it into, but we don't have anything that specifically would be like statute 865 talks about
septic.
rooms.
Yeah.
Question. As we discussed last, I'm not a fan of septic tanks, but
nobody is.
If you have a house, because to me, the way I read this is somebody saying that they misrepresented the house as a 4-bedroom house. Mm-hmm. Well, the house either has 4 bedrooms or it doesn't, irregardless of whether it's only perked for 2. So what are you supposed to, I mean, how does that work practically if you have a house that's 4 bedrooms but it's only perked for 2? I mean, as a buyer, I would say, I'm not going to buy the house because it's 4 bedrooms right, and I can only use theoretically 2 of them. So you go get your letter updated or expand your septic tank or whatever you need to do to get it to perk for 4.
And that's because it lowers the value of the house.
Correct. But I don't necessarily think they misrepresented the house as a 4-bedroom house when in fact it was.
Yeah, it looks
they probably didn't disclose that it only perked for 2.
Well, and the respondent says that they pulled it from an old MLS listing. So
4-bedroom?
The 4-bedroom. So,
but
but instead of going to the house and walking the house too and getting the septic letter.
I don't think walking the house, I mean, it was a 4-bedroom. It said it was a 4-bedroom. Yes. It is a 4-bedroom. So they didn't make a mistake there.
So the septic letter is the only problem then.
Yeah. Also, remember when we're talking, Jeff brought up a good point. When we're talking about adverse facts, you have to have actual notice or knowledge that, so they would have to have actual knowledge that they knew that, I don't know, 2 or 4.
The way you get the actual knowledge is you go get the septic letter.
And that led to my question: is that a requirement, or
but it goes to skill and care?
A good agent knows to do that.
A good agent.
So that was my question. Yeah, so they haven't violated any
No.
They didn't.
They violated skill and care. That's what they violated.
Got it.
So letter of instruction was the motion.
I think
yes.
Yeah, I think I'm prepared to accept council's recommendation. The strongest thing I could support would be a letter of skill and care and instruction. We don't.
Can we do that then? Can we have that then? A motion? There's not a motion already on it. Would you like to make that motion, Mr. Ferris? You wouldn't, would you?
No, he wants to. I'll make the motion that we give this respondent a letter of instruction detailing their obligations to exercise reasonable skill and care.
Second.
All right, we have a motion by Mr. Diaz and a second by Mr. Moffitt. Any other discussion? All right, all those in favor say aye.
Aye.
All those opposed?
No.
Okay, 3 no's. Raise your hand if you're no.
6-3.
All right.
2.
That's a 8-2. 8-2 vote.
I don't think it can be right. There's only 9 of y'all.
I said yes.
Yeah, he said yes. He changed.
I just didn't want to make the
what
motion.
What did I say? I want to say it's a long day, but it's only 12:30.
It feels like it's
Okay.
You gave us
7
an
to
extra
2.
commissioner.
Mr. Grant and Ms. Talbert were the no votes. Okay. Now, number 15 is you, Ms. Smith.
I pulled 15, and the main reason I pulled 15 is because we had such a large audience today. Wait, I'm not. And the reason I brought it up is because the complainant is a Texas resident and a timeshare owner, and so he wanted to sell his timeshare. So he got his offer from someone who used a public source and used somebody else's name and office number and license number. So I think it's important for us as realtors to pay attention and know who we're dealing with. I don't know that we can do anything about this particular case number, but it did concern me that we, obviously, if anybody wants to do something illegal, they can do it. But it bothers me sometimes, and I'm guilty of getting a phone call and saying, I'm not in your association, will you give me a one-day code? Well, I go to Verify or someplace and look it up, yes, but maybe I need to use a little bit more skill and care and say, send me some more identification, because we're allowing people we don't know to go in our homes. And then also this particular person paid $25,000 in fees to sell a timeshare to someone who didn't exist. I think that's scary.
Yeah.
And the other comment that I'll make is, I know this came to us because it involves a real estate license, but what else happens to these complaints? Do they go to another agency for investigation, or?
We can refer it to the Division of Consumer Affairs
Or the district
or
attorney's
the
office.
Attorney General's
Attorney
office.
General.
They have a consumer affairs division, right?
The Consumer Affairs Division is in the Attorney General's office. They moved over to the Attorney General's office now. So on a second,
It may have come from there. That's all right. We can ping pong it back to him. That's fine.
oh,
Well, since across state lines, we can go federal, can't we?
to who?
Just like making your life difficult.
I really hate that the people in the audience can't see Anna's face.
I know. I loved it in Knoxville when they could.
I want to play poker.
And it says they may or may not even be located in the United States. It's just scam everywhere. Yeah.
Nice. Now we got Interpol. Come on,
I don't
Anna.
think there's anything we can do about this.
I think this sounds very similar to the issues that we had once before. And this didn't come from the Division of Consumer Affairs, so we can send it over there for a referral if you would like.
I make the motion.
Second.
Okay, we have a motion by Mr. Ferris and a second by Mr. Diaz. Send to Consumer Affairs. She just said it didn't. All right, any other discussion? All those in favor say aye.
Aye.
All those opposed? That motion carries unanimously.
Who made and
Mr. Ferris made the motion and Mr. Diaz seconded. The next one is 16. And my question on this one is this an LLC?
No.
Okay. Then someone needs to make a motion to close it.
Except
Well,
recommendation.
their discussion. They had a discussion recommendation.
Oh, yeah, it was to, no, it's to close on
So
16.
16 is to close. I make a motion to accept
Second.
council's recommendation.
Okay, we have a motion by Ms. Tolbert and a second by Mr. Moffitt that we accept council's recommendation and close it. All those in favor?
Aye.
All those opposed? Motion carries unanimously. All right, number 17. Okay, I have written here there were multiple offers and no financial contingency. This was the one that was for discussion. All right, so y'all look at this a minute.
Why does it matter?
Doesn't matter to us. Doesn't matter to us at all.
Basically, there was not a contingency. One offer fell.
Well, there was no contingency. There was no
There's no-
financing
there-
contingency.
Right.
And that's what I'm wanting to know. Was there no financing contingency?
There was 70%, but they didn't say it.
Do you have a copy of that contract?
Yeah.
I just don't understand.
No.
That was just
Doesn't matter.
just Dennis getting stopped.
Yeah, he just did that.
Purchase and sale agreement, is that? Yes, I have a copy of it.
Okay. All right. So, does it? This says the let's see. Given the nature of the market and the multiple offer situations, it seems the respondent thought it best to leave out the contingency.
So is there a contingency?
So, is there a contingency on financing? And if so, what is it?
You think he's remarking about a financing contingency or a sale of home contingency?
So there's one that says for financial contingency loans to be obtained. That's paragraph A, and then for B,
Is it checked? Is this a TR form?
yes.
Okay. So, is it checked that there is subject to a financial contingency?
There is states that to 80% covered by
That was contingent on it being the sale of their property in the other side of the state.
oh so but there's not I don't see a box checked for financing contingency waived, but I don't see a box for financial contingency. I don't see that.
Will you scroll down to stipulations, special stipulations? I've got a bunch of realtors sitting behind you wanting to show you how the form.
Stop it! Don't look at my computer. Leave me alone. If you're looking at my computer, it's a violation.
I just thought it could be under special stipulations.
It's blank.
Okay, then it's not.
Well, biscuits. Hold on. There are 2 purchase and sale agreements.
There's 2.
I sigh. I can feel eyes on me. I'm just gonna keep making it smaller.
I thought the audience was representatives from the timeshare industry.
Well, you don't know they're not.
What would you say? We can hear you.
You thought they were all from the timeshare industry.
Wow, there are 4 purchase.
There was might be 8. They had 8. She said there's 4. I said there may be 8 because there was
The
8.
complainants are the buyers. They had 4 different contracts they sent you.
But I think they're complaining now because they had to split the earnest.
It did have to
Lost
split.
their earnest.
They lost
They didn't
half
say they
of it.
lost it. They just said that they negotiated it out with no terms.
What's an independent?
Well, yeah, I didn't know what an
Okay.
independent release is either. I think that's when you write it on your own sheet of paper or something and don't use
Sorry,
the
y'all. There
TR
are
form.
6 or 7 purchase and sale agreements. I think I found the last one.
Can we defer this till next month and get more information? This is
We
too
need-
convoluted to have
I don't
6.
think we need more information.
We're finishing this today.
You have no choice.
They wanted the contingency because they had to sell a property. So they told, because here's why. In this market, if you put a contingency in there, you're not getting the house.
I'll
So they
volunteer to
put
look
But
it
at
in.
there's no
and then
point in
leave.
putting up a contract if you really do have a contingency, and I got to sell my house to buy this other house.
If it's not written, it's
So-
merely conversation.
Correct. So
That's why I'm worried about 6 contracts.
So they defaulted on.
the agent, though, should have. I mean, I think the gripe is that there's no point in putting up contracts for a contingent sale if that in fact is the case, and not having a contingency in there. I mean, you just got to face the music. If you can't buy another house without selling your house, then you write it in there. And if your contract
And so this she's saying that they told her not to write it in.
correct, that's the beef.
That's the problem with the realtor right
Right.
there, the licensee.
Yep.
All right,
There's
you're
no-
recused. You're
I
recused.
offered to read it so I could recuse myself, which means I
There's-
leave.
Hey, it's not your birthday. I need to get on the road.
There's no point in writing a contract just to lose earnest money because
You still
want it
get to
accepted.
vote on number 20.
Something wrong with this realtor. That's what
Yeah,
I'm saying.
35.
Don't lean. There's
It was taken off.
6 contracts.
No, 35 is still on, and I guess
need to
we just
stick around
accept
while
the new
this
ones.
is.
We didn't know they pulled the new ones, or do we have to discuss
What?
the news?
We only have one more after this.
Yeah, but
And 2 more new ones. Yeah. No, they have not been read. They weren't pulled. They weren't.
Fair to this. Have them accept a contract and
Approve that though.
well,
You got to prove.
You got to prove it.
I know with the
that
contract. But why are there 6 contracts?
Well, they might have
6
6
offers.
offers. 6 offers.
How would the buyer have copies of those offers?
You okay?
At the hotel. Are y'all going back home?
We're going to Grove Park. We're going.
Oh,
You're going where?
Grove Park.
Oh,
Yeah, you got to get on the road.
Well,
I can advise the commission
Listen, everybody.
that I was correct that there is not a financial contingency in the purchase and sale agreement. Huh?
Home contingency.
Yes, what
But
he
there
said.
is a financial contingency.
Correct. Yes.
But not a sale of home.
No.
No first right of refusals. Nothing.
No.
Okay. All right. So this was for discussion. He didn't give us a
Correct. Let's
recommendation.
Dennis.
So I need a motion. If anyone is so inclined.
I'll make a motion for a $500 fine for
Civil penalty.
civil penalty.
Civil penalty, not fine.
Individuals.
I'm as tired as you are, Anna.
I just need
So a
to
civil
correct it
penalty
for
of
her.
$500
Thank you.
for
Or the violation of what?
well, just due diligence. I mean, you got to do your job.
Reasonable skill and care.
Reasonable skill.
Okay.
Even though she might have been encouraged, she still needs to do it. Yeah, I'm ready to go.
All right. So we have a motion by Mr. Beckley and a second by Mr. Gwynn. So does anybody have any other discussion on this topic? If not, we're going to vote. All those in favor say aye.
Aye.
All those opposed? Thank you. That motion carries unanimously. The last.
I abstain from that.
Oh, okay, yeah, you need to abstain. Okay. Okay, the last one is number 35.
31 got dropped.
22 got dropped.
22 got dropped.
Basically, I just wanted you to make a determination of what you thought about Respondents Council's offer and what I said. So they're asking. The original recommendation was a $1,000 civil penalty. They're requesting it to be dropped to $0.
This is unlicensed property management.
Correct. They're requesting it to be dropped to $0.
For what reason?
That the principal, so they provided a statement stating that the principal owner is a licensed affiliate broker, and they're in the process of upgrading their license to a broker license. They can obtain property management. And stating that for the fact that they're not managing third parties and they're only managing properties that, that they're also or that they are directly through an entity, that they would like for their civil penalty to be reduced to $0 since they're in the.
Oh yeah, I'm not licensed, so I want no penalty. Correct.
They have.
Yeah, I see.
Can I make a motion to accept what you've suggested here?
You didn't suggest anything.
Yes, you did.
Oh,
Yes,
yeah,
you did.
All right.
That we can decrease it to $500 should they secure licensure within 30 days. Because
Okay. But if it goes 31 days, no.
back to 1,000.
Back to the 1,000.
They start over again.
Here's the thing,
You're
and you
comfortable
saw
with
it today with Mr. Willoughby. We have got to be consistent in what we do because they will call you out on it. And so if we've been charging $1,000 for unlicensed activity for the 9 years I've been here, then, I don't know why we charge them $500 would be my beef with this motion.
When does the 30 days start?
Upon a reason that I suggested the 1,500 is that we did offer that to several entities at the last October meeting that were unlicensed property management, and that was the reasoning behind it.
I didn't like it then either. I'm just saying, let's just, I'm just one vote. Let's all be on board with, if we're going to allow people to be unlicensed and give them 30 days, let's just be consistent in it. So if that's, who made that motion? Stacy didn't. Who seconded it? Okay. Any other discussion? Are we clear on what the motion is? Okay. All those in favor say aye.
Aye.
Any opposed? No. All right. So we have 7-2.
The last two that I have for you are on the addendum.
And were those not considered? I'm questioning.
If you want,
As a part of the consent agenda.
If that is fine.
And we
if you
didn't
would
pull
like-
them.
Yeah, I mean, they can be. I just wanted clarification. If you're fine with them, I can just say the numbers in the record and we can accept the recommendation.
Okay, so the first one is approve the agreed order in which the respondent voluntarily surrenders his affiliate license. So
The first one is would have been a final hearing, the formal hearing for today.
And instead, this is what they're offering
Yes.
as a voluntary surrender.
Yes.
And so they would have to wait 2 years before they could come before us
So,
to ask for an affiliate license.
I can read you the exact stipulations that have been put in here. They're far more extensive.
No.
Than
We can
the
read your new
previous one
information.
we just saw.
Yes.
Thank you. That they can't pay Mr. Willoughby and keep coming back to, basically.
And this person has moved to Texas.
Yes, but we wanted to included information in the agreed order should the individual decide next week they're not moving to Texas and would like to have their license back.
And can I just make a plug for the Arello disciplinary database? This is how the people in Texas, if we put our stuff on this Arello database, and I don't think it costs us anything to do it, it's just a matter of uploading it, then Texas has that information, or if it goes to Arizona or anywhere, they're going to know. And that's really important when somebody has done what this person's done.
Right. Understanding is there.
I don't care. I don't want them doing real estate in Texas or anywhere else. But Texas is not going to know unless we do that database. I'm just making that statement. So, did we intend to leave these off? I thought they were included in the consent agenda, unless somebody wants to have some.
I think we have to add them. Because they are
Okay. All right. So, okay.
Accept council's recommendation on, or these like 1 and 2A.
I was going to add them as 36 and 37.
Okay, 36 and 37.
Okay, we have a motion by Ms. Tolbert and a second by Mr. Diaz. Any further discussion on it? All those in favor say aye.
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 Any opposed? Motion carries unanimously. Now on to number 37.
Oh, I thought was for both.
And was that for both of them?
Yeah.
Okay, good. Okay. All right, so we're getting close, people. We're getting close here. Okay, so the last thing is commission discussion. Does anybody got anything up for discussion?
No.
All right, I know y'all want to leave real quick. Just let me make one thing. I want to put a bug in your ear because I keep hearing about it at Arello, NAR, all these different places. Is we now have several real estate firms who are totally online. Yes, they still have to have a brick and mortar office because that's statute, and that's something that we can't change. But those offices are a 10 by 10 with nothing inside of them, just to have. Well, they don't even get their mail there. They don't even get their mail there. Just to comply with the law. So I'm just wanting to put a bug in your ear about this, because more and more, and I can tell you, I've got a brick and mortar. I'm required to have one, and and I pay rent, but I don't have agents coming to my office very much at all, unless we're having some event, some class, something like that. I could do that anywhere, though. But we have we're not here to tell somebody how to do their business model, but we are telling them, but you've got to have some 10 by 10 rooms somewhere. We need to start looking at that, start thinking about that. We cannot change the statute, but I'm telling you that nationwide, that is starting to change. The brick and mortar is starting to change. So I'm just wanting to put that be in your bonnet, to be thinking about that, to be noticing if you see problems with it, because just like the state of Tennessee, who 2 years before the pandemic moved the majority of the people out of this business and moved them home, and they are still at home doing the work of the state, and they have higher productivity than they did before they went home. And now I saw something on the news this week that now that people have gone back to the offices, that productivity has now gone down. So, I mean, I don't like we do it because it's the way we've always done it. With the internet, everybody sends contracts, the signatures, everything. about the only thing you do is deliver a check, and a lot of that is transfers. So I just want you to be thinking about that, because I see that coming down the highway, so we can be ahead of that.
Well, I mean, I could see the necessity. I could see the need for a brick and mortar place because council needs to be able to serve process. So they need a mailbox somewhere. And,
Well, you'd have to have a mailbox somewhere, for
yeah,
sure.
Or someplace that, you know, a process server can go to and say, you've been served. So I don't.
He's leasing an office and there's nobody there ever. Whoever gets served is going to have no success. They're going to have to go find them at their house. So I don't think I agree with Marcia. I don't think it makes sense to mandate people have to have an office. And the only reason they're doing it is because they're complying with the law and they're not using it, or the public can't access it. The public can't come to it.
I've been a realtor so long that there was a point where each realtor had to have a desk. Each realtor had to have a phone. We don't have that anymore. I mean, let's don't keep doing things the way we've done them just because we've always done them that way. I'm just saying, just be thinking about it, because it's heading this way.
Right. There are certain things we'd have to change in the statute and consider, because we do have certain matters that are required to be sent to firm addresses, such as our E&O letters are required to be sent to, if an affiliate is suspended. Three letters are sent, and 2 of those 3 letters are sent to the firm address, 1 to the affiliate and 1 to the principal broker. And that is statutory. So if we were to consider this, it would be a statutory change, not a rule change.
Oh, for sure.
So, I mean, I understand definitely the utility of it and the changes that we have. So it would be something to consider. But like Commissioner Diaz was saying, there is a need to have the ability to contact someone, especially since we have a requirement that individuals provide us a response within 10 days that we contact them, because we cannot just rely on sending individuals notices via email. Like, we're not permitted to just...
But if that's the case, you're more likely to get a principal broker at their home than you are at their office.
Right. So I'm just saying we have to have some kind of address. We just can't, like, we're not permitted to just send something via email, because as we were stating before, we do have very rural parts of the state that don't have very easy internet access. So in order to just state we're only sending things via email is not...
I don't think we're saying that.
Right. No, I know. I'm just saying, like, just in general, that there are other considerations we have to take into effect.
And we have a huge percentage of offices that consist of 2 people.
Right.
I mean, that's a obligation, a big obligation for 2 people versus somebody with 400 people.
There, also Eric Weisner, he's from
Kansas.
Yeah. They've gone forward with, I think, requiring email in their rule, which we currently don't have. But that would probably be something to consider with this, that we would probably need to require every agent keep their email up to date with us.
Well, the biggest step is passing the legislature, and I don't know how we would even get that done, except we have a big group of people here today that it might interest, and people listening might be interested, so they could talk to their legislators, and that's really the only thing we could do. Okay. All right. So let's go around the world. Let's start with Miss Kathy over here. Kathy, this was your second meeting? I'm sorry. I'm sorry if I got hot.
It takes a few meetings to get in the swing of things. Yeah.
No.
I've been a member for a couple of years, and I learned a lot today.
this birthday
I'm
girl?
not going to play Rocky Top today.
Oh, she played Rocky Top at the last game.
And we did succeed in
We
beating
did win that
Alabama,
game.
so
You need to play.
You should
I
play
know I should
everyone.
play it again. Thank you to everybody that has wished me happy birthday.
Jay?
Been a good meeting. Thank you all for being here. Anyone looking to be a proctor, should be trained. Probably not a probably don't need to be in the school of proctology, but
Find DJ on YouTube if anybody wants to.
Commissioner Gwen,
I'm good. I'm sorry to pick on Anna on the hyphen.
have you learned all you ever needed to know? He's a commercial realtor. Have you learned all you need to know about septics this week?
Not really.
Okay. Mr. Moffitt?
Oh, no, I'm good.
Ms. Smith?
It's been a good day. Safe travels to everybody going home.
Thank you, everybody, for being here. Be sure and sign out before you leave to get your full credit. And you got 8 hours today, so thank you for being here.
Oh, my goodness.
See ya. Yeah. Tell him I'm practicing.
Hey, DJ.
Hearing.
DJ.
And over stuff we've gone
That's what
over.
you're going to do? When the camera comes on you.
Willoughby? Yeah. Yes.
When the camera comes on you, give me a sign. Okay.
And listen. And she didn't even start out with him. She wasn't our attorney when this all started.
Bye, everybody.
Bye.
Bye.
Sorry for him.
Bye.
To me, and she said,
It's good to be with you.
All right. Head back to Jackson. Bye, Kathy. Be careful.
Yeah,
Bless his heart. I'm gonna have to. I'm gonna go home and ask my daughters about Venmo because I know they do it too.
Well, he asked our waiter, like, no, let me pay for these four. Because you think four together. And he's like, no, you.
I told him in the.
And he's like, oh no, like he's arguing. No, she's got it. She's got it. Okay. No, Venmo. I mean.
Oh, yeah.
The one line in
Oh, you should have seen him. He was totally focused on it.
Watching, he was like, I was ready to take him.
Yeah, I knew he was.
He was ready for whatever.
I knew he was.
I've never gotten that angry before, but like afterwards, I was
Thank
up
you,
there
Aaron, for everything.
exhaling with Aaron because like he
Like the,
I get it.
why didn't you see your I took it all I could.
I was like, let him say something.
Yeah.
As he's gonna say.
Yeah. I felt very.
All right, sir. Have the cash. Get out of here, so I can.
I gotta go to the restroom anyhow.
All right, just meet me in the right. Meet me right there.
My stuff.
Okay.
Bye, granddaughter. Bye, Aaron. Bye-bye. Have a good one. Hey, hon. Take care.
Shouldn't get loud with people.
No.
I know.
No.
Hey, brother man.